On behalf of the American Enterprise Institute and the Boyd and Gray Center for the Study of Administrative Law, George Mason, I'd like to welcome all of you to this conference in honor of Judge Laurence Silberman. I couldn't think of a better way to celebrate his life and career than to have a conference where we would talk about the ideas that were so dear to him. The separation of powers, which will be the subject of the first panel, administrative law, the subject of the second panel, and foreign affairs and national security, the subject of the third panel. The reason why I think we thought to celebrate him here at AEI with a conference about ideas is because Judge Silberman loved ideas. He loved ideas because he thought all the good ones were his ideas. The bad ideas were foisted upon him by his clerks, many of whom are here in the audience today, and of which we hope to have one on each of the panels. But I think when we were talking about how to commemorate him, we thought that we would have a panel that not just include the ideas that were dear to his heart, but also represented different phases of his career. So the first panel on the separation of powers, which will be hosted by, let me introduce her, Jen Mascott, a professor at George Mason Law School and also co-head of the Gray Center at George Mason, encompasses his remarkable career before he ever was on the bench, when at such a young age he became solicitor of the Labor Department and became Deputy Attorney General during one of the most fraught times in our history, the Nixon period and the Watergate period. Then went on to become an ambassador to Yugoslavia, but had such a wealth of knowledge about the inner workings of government that were finally expressed in his wonderful opinion that became Morrison versus Olson, where he found that the independent counsel statute was unconstitutional. And then the second panel, administrative law, I think also encompasses in part his time as a labor lawyer and then as solicitor labor, but also his time as a DC Circuit judge, where I think he became known as the champion of the Chevron doctrine, the idea that judges should defer to the interpretation of ambiguous statutes rendered by the implementing agency. As you can tell from the length of my description of Chevron, as a Yale-trained lawyer, when I came to clerk from at Harvard, I stopped paying attention when he said statute. I never really understood the Chevron doctrine, but I did know he was utterly loyal to it all the way to the end. And then the third panel topic, foreign policy and national security, I always thought was really his love. I think he really loved foreign policy and national security, and I often accused him of doing law just to pay the bills so that he could get to do foreign policy and national security. I know that when he was here at AEI, in between his times in government, he loved hanging around with the foreign policy and national security scholars. And then I think this was when he rendered perhaps his greatest service to the nation, was when he was a co-head of what became known as the Rob Silberman Commission to understand the failures of the intelligence agencies over Iraqi WMD leading up to the invasion of Iraq in 2003, and for which he was awarded the Presidential Medal of Freedom. So thank you very much for coming today. I think we have a wonderful set of speakers. We have a wonderful conference ahead of us. We're going to be treated at the end. I don't think it's Nicole, is it secret anymore? Can I say we'll finishing up at the end with Paul Gigot of the Wall Street Journal editorial page, who will be interviewing Justice Amy Coney Barrett, yet another Silberman clerk. Join me in welcoming the first panel, headed by Jennifer Mascott, who will introduce the speakers themselves. So thank you very much for coming this morning.
All thrilled to be here today, and there could be no more distinguished jurist to honor today than Judge Silberman and his storied career. And so the Gray Center is happy to be part of this along with AEI and start with such a rock star panel. The Gray Center has a lot of fond recollections of Judge Silberman, starting with him being the inaugural recipient of our Justice Thomas First Principles Award several years ago, and then the Wall Street Journal editorialized him as perhaps the most one of the most significant jurists who has never served on the Supreme Court. So we'll talk a little bit more about his influence, particularly in the area of separation of powers with the panels this morning. We also were grateful at the Gray Center to have Judge and Mrs. Silberman in 2022, sadly just several months before the judge got sick, who was so kind to come to a dinner with the course that we have with Justice Kavanaugh there at the law school. So very committed to keeping up with his clerks and engaging with law students, and an excellent jurist. So to start a discussion about his legacy and separation of powers, we have a former colleague of the judges on the DC Circuit, Naomi Rao, who's familiar to many here, who founded the Gray Center a number of years ago and was a professor at the Scalia Law School for many years until she started serving at the head of the Office of Information and Regulatory Affairs during the Trump administration before her appointment to the DC Circuit. Served in numerous capacities before then as an attorney in private practice and also in the White House counsel's office prior to her academic career. And after her remarks will be followed by Professor Sai Prakash from UVA, who's written extensively in the area of separation of powers and executive power. He is the James Monroe Distinguished Professor of Law and the Albert Clark Tate Jr. Professor of Law at UVA. And if you have not read his books on presidential power, pick those up because we actually teach from them in a seminar that I do at Scalia Law School. And then we'll also hear from Professor Rachel Barkow, the Charles Seligson Professor of Law and the Faculty Director of the Peter Zimrow Center on the Administration of Criminal Law. And I should say both Professor Barkow and Professor Prakash are former Silberman clerks. Professor Prakash then went on to clerk for Justice Thomas and Professor Barkow for Justice Scalia. And so there really couldn't be any more great scholars to start us off and former colleagues. So, Naomi, why don't we go to you?
Great. Thank you so much, Jen, for that introduction, and thank you to AEI and to the Gray Center and to all the organizers for putting on this for this wonderful conference. It is such a pleasure to be here to celebrate Larry Silberman's legacy, to be here with family and friends and colleagues. So the seat that I held on the DC Circuit belonged to only two other judges. It was established in 1984, and Judge Silberman was the first occupant of the seat. It was then followed by then Judge Kavanaugh. So I'm very mindful that I have a lot of big shoes to fill. But I consider myself exceptionally lucky to have served with Judge Silberman for a number of years before his passing. We spoke all the time, several times a week, almost every week. We talked about cases, we talked about the law, and everything else that was happening in the world. I find myself thinking about him frequently and wishing that I could ask him about some tricky case or some legal nugget, hear what he had to say about things that are happening on our court or around the world. And so Larry's legal legacy looms very large, in many ways too large for even a whole day conference. But what I cherished most about him is how he lived his life with so much zest and joy and a kind of devilish sparkle. But to be honest, I don't think Larry would have wanted a lot of sentimentalizing today. So I will turn to the subject of this panel, which is separation of powers. And Sai and Rachel are going to speak more about the judge's cases and legal work. And so I thought I would talk a little bit about his unique background and how that contributed to his understanding of the separation of powers. So Judge Silberman served in multiple positions in the executive branch. He was the solicitor and undersecretary in the Department of Labor, where he learned firsthand about administrative agencies and how they work, or maybe how they don't work. He helped lead the Department of Justice during Watergate, as John Hughes already mentioned, and he was ambassador to Yugoslavia at the height of the Cold War. So I have my own experiences in the executive branch, perhaps less storied than Judge Silberman's, but we often discussed how checks and balances work in practice. We talked about the traditions and the compromises and the boundaries that were important to resolving separation of powers conflicts. And I think that we both had a sense that working in government, one learns a lot about the way one branch may wage an incursion on another in subtle ways, and then, of course, sometimes not so subtle ways. I always felt that Larry kind of understood, kind of in his bones, the importance of separation of powers to our constitutional form of government. And of course, the importance of separation of powers to individual liberty. And I think this experience was very relevant when it came time, for instance, to determine the constitutionality of the independent counsel statute in the case that then later became Morrison v. Olson. Judge Silberman's masterful opinion formed, of course, the foundation of Justice Scalia's famous but lone dissent at the Supreme Court. And in part because of his experience, Larry would know the wolf that would come, no matter how carefully it was cloaked in sheep's clothing. And while some version of the unitary executive has now been, I think, much more widely accepted across the jurisprudential spectrum, it was far less obvious and less well accepted when Morrison was decided. So I'll let Judge Silberman, I loved what Judge Silberman once said about the unitary executive. He said, this was in a conversation with Stephen Breyer, he said, asking me to speak on the doctrine of the unitary executive is very much like asking General George Pickett to speak on the future of the Confederacy after the Battle of Gettysburg. For just as historians love to point to Pickett's charge as the high water mark of the South's effort to secede, some legal scholars have labeled my opinion as the brief apogee of a constitutional lost cause. So, I think, he's come to see that perhaps it wasn't a lost cause. But for Larry, experience in the executive branch was not just useful for understanding executive power, it was also very important for informing the limits of the Article III power. And Larry was very adamant about the limits of the judicial role and very critical of judges who stepped beyond those limits. Judges shouldn't be politicians, and they must above all be independent. They have to be unconcerned with things like the greenhouse effect or any other political or social pressure. And so there's a lot that's often discussed about Judge Silberman's commitment to judicial restraint, and he often spoke about it in those terms. But I do think we have to be a little careful about what he meant here. And judicial restraint is sometimes the rallying cry for judges to stay their hand, to decline to exercise their power, even when a case is properly before them. And as far as I can tell, Judge Silberman never espoused this pusillanimous view of the courts. And I don't think anyone who knew him would have said that he was timid. If there was a legal issue that was properly in a case, he recognized that it was his duty to decide it. And so he pointed out the boundaries of the judicial power as a matter of principle, not out of fear of deciding hard questions, and certainly not because he cowered from public criticism. And so while he often spoke about judges not overreaching, I think his dozens of masterful opinions made quite clear that underreaching was not the solution. He was also a very frequent and vocal critic of the Supreme Court and of other judges. It was a trait that I saw sometimes vex my colleagues and other judges that came under his scrutiny. But I think his sharpness came from the fact that courts must be self-policing. Our independence imposes additional burdens on us to check ourselves. So in Judge Silberman's own words, he says, we have to worry more about an imperial judiciary than we do about an imperial presidency or an imperial Congress. We can throw the rascals out of the executive branch or the Congress. We cannot throw them out of the judiciary. So I think that was a big part of where some of his critiques came from. And Larry, of course, was a legal formalist. But I think he also understood the contingency of personal perspectives and the fact that his experience in the executive shaped his views. He had said, where you stand may depend on where you sit or have sat. And I've often wondered if my own views would have been different had I served in the legislative branch. Indeed, Congress was the branch that Larry hated to think about. He told me that he picked his office in the courthouse to be as far away from Congress as possible. He didn't want to look out of his window and see the Capitol. He said he shuddered at the very thought of it. But this conference is also about looking forward, and perhaps it is high time for us to think about applying some of Judge Silberman's wisdom to the first branch of government. The weakening of Congress in relation to both the executive and the courts is perhaps the most important separation of powers issue of our time. The Supreme Court is now grappling with Chevron, and at least some justices are grappling with the principle of non-delegation. And I think it is only too obvious that making the government and the administrative state more constitutional will require not just a unitary executive and careful judicial review, but also for Congress to do its job. And I know for me and for many others, Judge Silberman's legal legacy will continue to provide guideposts for grappling with some of these perennial questions about our limited government and our Constitution. Thank you.
Well, it's a pleasure to be here with you today. William Manchester, in his multi-volume biography of Winston Churchill, described him as the last lion. He was wrong. Judge Silberman bore a strong resemblance to Churchill insofar as he lacked hair and had a pugnacious demeanor. But when I think of Judge Bork and Justice Scalia and Judge Silberman, the judge could also be said to be called the last lion. He was a lion for the rule of law. Not the rule of politics. He was a lion for the separation of powers. And above all else, he was a lion for judicial restraint. I am eternally grateful for the judge for having hired me. He took delight in reminding me of that fact. When I first joined his chambers, he said he believed in affirmative action for Yale law students. And I think he must have said the same thing to John as well. The judge left an indelible impression on all his clerks, and he's left an indelible impression on the law as well. I'm going to talk about two cases. The first is Independent Insurance Agents of America, and the second is Morrison versus Olson. So judicial restraint has many facets, including the idea that judges should resolve only those legal claims raised by the parties, an idea referred to as party presentation. Courts justify that principle in terms of notice and prejudice. The idea is parties can't respond to an argument if the judges come up with the argument themselves. So it's unfair to them. And of course, it's perhaps unfair to the law as well because there's no adversarial presentation. Another justification rests on the nature of our adversarial system. When the courts come up with issues on their own and decide cases on that basis, they're almost inserting themselves into the process as advocates and litigants and forgetting their proper role as neutral arbiters. So in this case, Independent Insurance Agents of America versus Clark, the court discussed Section 92 of the National Bank Act, something we're all familiar with, which authorized any national bank located and doing business in any place, the population of which does not exceed 5,000, to sell insurance. The parties differed as to the meaning of this section. Rather than address the meaning of this section, the DC Circuit took a different tack. They decided that the section no longer existed in the US Code, that the statute had been replicated, that this particular provision had not been replicated by Congress when it recodified the statute, and therefore there was no Section 92. So despite the fact that both parties thought there was a Section 92, the court decided the case on the basis that there wasn't. Judge Silberman dissented on the grounds of party presentation and the inability of courts to go beyond that. It might be thought, he said, counterintuitive to decide a case on the basis of a statute that might not exist, but he said courts do not owe an abstract right to Congress or the president to enforce or not to enforce a statute, but instead have only the authority to decide the case or controversies presented to them. And because the case or controversy as it was brought to the district court or on appeal did not include the question of whether Section 92 actually existed, the court couldn't decide the question. It is quite fair, he said, to say that we have added to the case, we have created a controversy that did not exist below and that was not argued by the parties. In so doing, he said the court had exceeded its proper authority as a proper Article III court. Quoting a D.C. Circuit opinion by then Judge Scalia, he explained, "The premise of our adversarial system is that appellate courts do not sit as self-directed boards of legal inquiry and research, but essentially as arbiters of legal questions presented and argued by the parties." The Supreme Court rejected Judge Silberman's approach. It reversed the D.C. Circuit on the merits of the case, but it said the D.C. Circuit had not abused its discretion in pursuing a legal argument not raised by the party. So the judge seemed to have lost on this point, and he was, I think, a little upset by it in the years to come. But much later, some 30 years later, the court would give him a partial vindication in a case called United States versus Sinanang-Smith, where the court rebuked the Ninth Circuit for raising issues not raised by the party and argued that the Ninth Circuit had abused its discretion in so doing. And so this was a partial victory for the judge, not a complete victory, because it seems as if the Supreme Court has the view that lower courts should follow the principle of party representation, but not the Supreme Court. And that's a sort of a theme of the Supreme Court. It's certainly a theme of the Judge Silberman's critique of the Supreme Court. Do I think the judge is right? I don't really know. It's a very complicated question. Whether courts should only follow the arguments made by the parties or should raise arguments sua sponte. On the one hand, they have a duty to follow the law. On the other hand, you might think the party should control the case. But of course, we know there's an exception to that. That's the question of jurisdiction. Even if both parties agree that there's jurisdiction, the court is supposed to consider that sua sponte. It's a very complicated question, but I think we can all benefit from reading his opinion in the case because it lays out his principles quite clearly. A few words about Morrison versus Olson. Morrison versus Olson is about the constitutionality of the independent counsel statute. Alexia Morrison was pursuing Ted Olson and other people for violations of federal law. And as the case was before the D.C. Circuit, one of the questions was, is the for-cause removal protection in the statute, the independent counsel statute, constitutional? There were many other questions as well. I want to focus on that one. Judge Silberman said that the court's jurisprudence in this area divided or distinguished between executive branch officers and so-called quasi-legislative and quasi-judicial officers. In Myers, they had said the president can remove all, but in Humphreys, they had said that the president didn't have a constitutional right, an unfettered or illimitable constitutional right to remove quasi-legislative and quasi-judicial officers. And so the judge, looking at that dividing line and thinking about the president's role as the recipient of executive power and thinking about the president's duty to take care of the laws that be faithfully executed, concluded that the restriction on removal in the independent counsel statute was unconstitutional. And it seemed like he was on solid ground until the Supreme Court took the case. And in the 7-1 opinion written by Rehnquist, Chief Justice Rehnquist, the court basically changed its doctrine. Chief Justice Rehnquist said, our cases have suggested this dividing line between executive officers and so-called quasi-legislative and quasi-judicial officers. But our present considered opinion is that what matters more is whether the president is able to carry out his constitutionally assigned functions. And then the court quickly concluded that he would be able to, notwithstanding the for-cause removal protection. The court really didn't pause to think about its test, what it would mean for the future or what it meant for this case. Would the president be able to carry out his constitutionally assigned functions given the removal protection? Would the president be able to perhaps supervise and ensure a uniform execution of the laws if it couldn't remove an independent counsel who was creating discrepancies across prosecutors and laws? They didn't even sort of approach that question. And then they didn't think about what it would mean going forward if, as Justice Scalia pointed out in his dissent, if Congress can create an exception and permit removal here or permit restrictions on removal here, where else could Congress impose removal restrictions on the president? I think as Justice Scalia thought, this would be death by 1,000 cuts. It was a, quote, open season on the executive. I think Judge Silberman was absolutely right in this case. It seems like a narrow restriction. It seems like a familiar restriction because these impositions have existed for quite a long time, certainly from the Civil War on, when Andrew Johnson faced a bunch of restrictions imposed by Congress because Congress didn't like the administration of Andrew Johnson. But if Congress can impose a restriction on removal, why not on the veto power, right? Require 4 cause for vetoes. Why not require 4 cause for pardons? I don't think that the Constitution authorizes Congress to impose these kinds of restraints, and Judge Silberman was absolutely right. I think he's been borne out by the recent changes in the Supreme Court's jurisprudence with respect to removal. The court is moving away from Morrison and has not yet repudiated it, but I hope it does in the future. I'll end, I'll end with an anecdote that the judge often used. If he were here today, I think he would remark with a gleam in his eye and a smile on his face, even a blind squirrel can find an acorn once in a while. Thanks so much.
Definitely lowering this after sigh. So thanks very much. It's an honor to be with you to talk about Judge Silberman's legacy, particularly with respect to the separation of powers. So he was so committed to the separation of powers that he wanted his law clerks to focus on it in every single case. Now, how can that be true? You might ask yourself, given that some cases don't raise those issues, and we were just told you can only look at the arguments of the parties. But the judge recognized that every case presents a separation of powers question because every federal case requires a judge to make sure the court is properly hearing the case and not overstepping the bounds of the judicial role. So he was adamant that the law clerks had to be on the lookout for jurisdictional defects. So you earned a free lunch if you spotted that a litigant lacked standing or a case was moot. Now, this wasn't just a fun incentive, particularly because the places he went to lunch were not good. But it was training. It was training for us so that we could see that courts are not there to resolve every political issue. They serve a limited role of deciding only those issues when someone has been injured, when they have a concrete injury. And I really don't think there's been a judge who sat on the DC Circuit who is more attuned to questions of standing and jurisdiction than Judge Silberman. And then there's a second way that separation of powers made its way into every case, and that's the one that Cy has already talked about, and that was his commitment to resolving only those arguments that the litigants raised. He knew that it was not the role of the judge to put words in the mouths of the parties before him, and I won't repeat Cy's excellent analysis, but I will recommend to you a really good paper on this that one of the judge's former law clerks, Judge Eric Miller, wrote that's in the Harvard Journal of Law and Public Policy that is another really good analysis of that issue and how the judge addressed it. So we have 2 kind of examples of that. Another example of the judge's commitment to separation of powers was reflected in his faithful adherence to the Chevron framework. And I particularly want to talk about that today because I know that is not so much in vogue, the Chevron framework anymore. So it's good to be reminded of why the judge thought that Chevron wasn't just a rule of decision that the DC Circuit applied 2 steps for statutory analysis, but in fact, it was part of that central view he had that judges should not make policy. So here's how he put it in a speech to the ABA in 1989. Chevron's rule that the federal judiciary must defer to an agency's reasonable construction of a statute if it is charged with enforcing, if Congress has not directly addressed the question at issue, is simply a sound recognition that a political branch, the executive, has a greater claim to make policy choices than the judiciary. So Judge Silberman recognized that, 1, laws would be ambiguous, either because Congress made a deliberate choice to leave things open-ended and give an agency a delegation to choose from a policy menu, or because a particular issue was unforeseen and Congress left room for the law to adapt. And so when those issues would inevitably come up, as between unelected judges and the executive branch making the policy calls behind decisions when there is ambiguity, he knew the power should rest with agencies and not with judges. As he put it, quote, "The agencies, even the independent ones, have superior political standing to the life-tenured federal judiciary in performing that policy-making function." Now, I should add, this wasn't just an abstract principle for Judge Silberman. He deferred to agencies during Republican and Democratic presidential administrations alike, to policies he undoubtedly agreed and disagreed with. He was committed to Chevron and leaving the matters to the executive no matter who was in charge. And I think another example of this commitment and the way the judge viewed the judiciary, I will say from a personal perspective, benefited me, was in how he went about hiring his law clerks. So he was willing, and in fact, I won't go so far as to say eager, but he did get a certain kind of perverse joy in having a few Democrats among his law clerks. And because he did that, because he recognized he was not staffing an office on Capitol Hill. He did not need to have people who fell in line with his same voting perspective. What he needed were law clerks who shared his commitment to the role of the judiciary. And there is no rule that says that's only Republican law clerks or Democratic law clerks. It could be either one. And so he was willing to hire those of us who were committed to those same principles, even if we didn't vote the same. And that did kind of make it more fun, I think, in chambers anyways, when we would discuss policy issues. But it's another example. And I will say, I think it's a pretty sad state these days with judicial law clerk hiring that so many judges have turned away from that. Because it is increasingly the case that there, particularly at the Supreme Court, that there's a litmus test for law clerks in terms of their political leanings that I think is completely unnecessary given the role of the judiciary. And I was very grateful that Judge Silberman did not follow that. Now, in addition to this very strong view of what the judicial role should look like, Judge Silberman's contributions to the separation of powers are also evident in how he viewed executive power. And as Judge Rao pointed out, I think a great deal of this comes from his vast executive branch experience. He understood the operation of federal government more than anyone I have ever met. And he used that deep knowledge to inform his legal analysis. So I too selected Morrison versus Olson as the case that is a good example of that. I, as Professor Mascott mentioned, I clerked for both Judge Silberman and Justice Scalia, and I think this case represented some of the best work for both of them. So I could kind of ride the Silberman-Scalia, Morrison versus Olson circuit to tell you how great both opinions were. But credit where credit is due, Judge Silberman went first. And his opinion is the clear blueprint for Justice Scalia's dissent. It doesn't have this wolf comes as a wolf line, which is clearly the best line written ever in a judicial opinion, but the legal analysis that Judge Silberman put out in his opinion really is the blueprint for that Scalia dissent. It's a sharp model of textual analysis of what executive power means, how it fits in with the Constitution's larger structure, and it really is brimming with those functional points about how the government works to show what the constitutional infirmity of the independent counsel law really was. So as Judge Silberman noted in his opinion, the independent counsel's freedom, quote, strikes at the very heart of the unitary executive doctrine, precisely because it wouldn't give the executive the ability to exercise that kind of oversight that Tsai alluded to. And he had great examples in his opinion. For example, first of all, he had a real world one where another independent counsel had tried to subpoena the Canadian ambassador, even though the State Department objected. I mean, that is a very good example for how it impedes executive power. But he also was sensitive, Judge Silberman, to the fact that there was a reason the independent counsel law was enacted in the first place. It had a functional purpose behind it that was very powerful. It was enacted in the wake of Watergate and a desire to spare the country a repeat of a crisis like that. And I think it's noteworthy that he confronted that directly in his decision and said, avoiding a kind of crisis like that, quote, that justification assumes wrongly, we think, that prosecuting presidents can somehow be made relatively painless. We do not see how such an eventuality can, no matter what structural techniques are employed, be other than a national nightmare. He also foreshadowed the problems with using an independent counsel. As he put it, in effect, an entire self-sufficient government agency is created from scratch to investigate and perhaps prosecute a single individual. Inevitably, the success of the office itself, in the public's eyes at least, must turn to some extent upon whether indictment and conviction are obtained. And he noted the independent counsel wouldn't need to view a particular case in relation to similar cases, past or future. Wise exercise of prosecutorial discretion is dependent in part upon access to officials who are participants in the ongoing process of enforcing the law and who are able to take a longer view of an individual case. A case that seems strong or important when viewed in isolation may look weak or trivial when measured against past cases or in relation to broader considerations of sound deployment of prosecutorial resources. When I thought I had 10 minutes, John, I had even more quotes, but I do think this gives you an idea just how closely the dissent by Justice Scalia takes the structural blueprint from Judge Silberman's opinion and just how sound his analysis was. And then he ends with something that I think is also really important, which he says, we have grappled with issues that we full well recognize divide the nation politically. And he's talking about the court taking up the independent counsel law. Federal judges, properly removed from any political considerations, partisan or policy, do not relish the task of deciding such issues. But great constitutional cases have often arisen out of the crucible of partisan struggle, cites Marbury versus Madison, and we have no alternative but to apply our view of the Constitution. This is no abstract dispute concerning the doctrine of separation of powers. The rights of individuals are at stake. So I do think that echoes what Judge Rao was pointing out is, when the case is properly before you, you have jurisdiction, the parties are making the arguments, and the constitutional question is teed up. Judges have to resolve those, and he didn't seek them out, but when they were there, he did what he thought was right. And he recognized separation of powers is always about individual rights, and he was a strong protector of those. At some point along the lines, he got the nickname Let Him Loose Larry when he served on the district court bench because he was so careful to the rights of criminal defendants. But I think if he deserved an alliterative nickname, I would have gone with Liberty-Loving Larry, or maybe Separation of Powers Silberman, because everything he did was in service of the Constitution and its structure, and he did it as well as anyone who ever wore the judicial robes. Thanks for letting me be part of this today.
That was really great. Thank you to each of you. We're going to, at the end of the time here, have space for audience questions, and we'll have some moderator-led questions, but I want to give the panelists a chance to respond to each other. But first, before we do, I should have also said in introducing Professor Barco that she writes extensively in the areas of criminal law and teaches in administrative law and constitutional law as well, and formerly served on the U.S. Sentencing Commission, the subject of another great separation of powers opinion by Justice Scalia, her boss at the Supreme Court. So
he referred to it as a junior varsity Congress, just so that no one thinks the way he talked about it was in a good way. So, yeah.
And also, since Professor Barco and Professor Prakash both discussed Morrison versus Olson, which in a sense, I guess Judge Silberman did lose 7-1 at the Supreme Court, actually circumstances have vindicated a lot of his concerns, because this is one very unusual area where Congress actually itself did figure out the trouble with the independent counsel framework, and eventually, after many, many years of reauthorizing it, let it finally lapse after President Clinton ultimately was impeached due to the many-pronged, multi-pronged investigation with Judge Starr that began under the statute. So we do obviously have special counsel investigations today, but those are operated under regulations at DOJ and other systems that do have a little bit more presidential and executive supervision over them, in a sense, because the regulations are put out by DOJ and there's more control than the independent counsel statute, even though it was never found unconstitutional yet by the Supreme Court. All right, so with that, do any of our esteemed panelists desire to respond to each other? Normally we do this on panels when there's debate and differing views, and you all are fairly well aligned in Judge Silberman's greatness, but anything you want to add?
I'll say that he was greater than the other two people said.
In what ways, Professor Prakash?
It's hard to count the ways.
Okay. All right. Any more concrete comments? Yeah.
I have a comment about Chevron.
Oh, good.
So I do think that Judge Silberman was committed to Chevron, but I think, like Justice Scalia, Chevron can be practiced in many different ways, and I think we have to understand Judge Silberman's sort of adherence to Chevron also in the light of the fact that he was a real formalist, and he believed that even really hard cases had right answers. So I think that means that a lot of things could be decided at Chevron step one, right? Like, did Congress speak clearly to something? And Scalia certainly took that view. So he believed that where there was really a gap, or Congress had given some authority to an agency, that there would be deference. But I think it was not the sort of generalized deference that sometimes people associate with the Chevron.
So I think it's true that he decided cases at step one when step one gave an answer, but he had a lot of step two cases. And in his speech to the ABA, he points out that he thinks it's really important when you do that to set out, these are the many reasonable interpretations that could be had. So he even would offer other interpretations that could be reasonable, but he would defer to the agency. So I think he was more than just giving lip service to it, frankly, more so than Justice Scalia, which I feel like I can say, since I'm not on the federal bench myself. I'll go ahead and just speak freely. Justice Scalia was a step one guy, and so Chevron, and he was on the Supreme Court, so they take no cases that really involve these issues. But you're on the DC circuit, you're on the Chevron circuit, and that's the place where Chevron mattered the most. And Judge Silberman sat on the circuit where it mattered the most, and he was a faithful adherent to it. And the reason was because when you have ambiguity, if you're going to go in there and try to ram and claim it's really step one, it's not. It's not. We all know there's ambiguity in the law. And when there is, do you want an unelected federal judge making that call, or would you rather have it be an agency that has some political accountability, has expertise to consider how the issue and the policy relates to the larger statutory structure and purpose? And Judge Silberman was quite clear. And I know it's on the chopping block, Chevron. If I was a betting person, I would tell you, it's going down. I think it's going down next year when the court decides two cases that raise the issue. But I think Judge Silberman would criticize those cases, and I'd be very curious to see how the Supreme Court writes the decision, because the other major issue is lower court judges have to apply whatever it is the Supreme Court says. And one of the things I particularly loved about Judge Silberman is he pulled no punches when the Supreme Court left the lower courts in a sea of complete confusion, because they didn't really stop to think how things would play out in lower courts, and they would issue these decisions that actually left all kinds of issues unresolved and made things worse. And one of the nice things about Chevron is that it does have a clean analytical structure to it that I think the DC Circuit has handled very well over the years. So if it's not broke, don't fix it.
So on Chevron, and maybe this is an obvious area where the panelists have a range of views, but and just to explain for our audience at home, or those of us here who are not as steeped in administrative law, Chevron deference doctrine comes up when the court's reviewing agency cases under the Administrative Procedure Act. And the question is, if the judge is faced with a question of law, but the statute doesn't seem to fully answer the case or the question that the parties have raised, and there's some ambiguity because oftentimes Congress, to many of the panelists' points today, has enacted very broad laws that it then doesn't update, so the agencies are operating under broad parameters of a lot of authority without a lot of concrete direction. So who decides what they're supposed to do? Does the agency get deference that it has reasonably filled in the gaps of the statute, or does the court have to fully wring meaning out of the statute at every point of the way? And I guess my question follow-up for you all is, some folks in arguing the case currently or writing about this would say, well, even if the court this year overrules Chevron, it could still be perhaps consistent with the idea of agencies at the end of the day having some kind of mandate to act under broad statutes, because the court may need to fully answer questions of law, but if the law runs out and it assigns the agency to engage in a policy task, then it's not really step two of Chevron, because Chevron's a legal interpretation, but instead it would move to state farm or arbitrary and capricious policy discretion. Do you all think that would be a view Judge Silberman would align with? So in other words, even if Chevron's overruled, there's still room for discretion but it would be under the policy framework. We're not any longer dealing with the question of law. So you fully interpret the question of law, and you only leave discretion for the agency if Congress has actually given it policy discretion.
I don't want to monopolize the time, but no, I don't think he would agree with that because I do think that it's about those questions of law that are not, they're ambiguous. So by definition, somebody needs to resolve the ambiguity, the agency or the court. And I think the thing he would have a problem with, and I'm just relying on his speeches and his words, so it's not, I'm not reading tea leaves, these are things Judge Silberman has said, that when that happens, let the agency resolve the ambiguity, not the courts. And so I do agree with you that there's a pocket of policymaking authority that still would reside with agencies, but that's a different question. It's not whether agencies still have any policymaking authority left. It's what do you do in the specific instance when a statute is ambiguous? And on that, Judge Silberman was quite clear.
And Judge Rao or Professor Prakash, any?
I mean, I'd like to say something. My vague recollection is I came up to D.C. once and had lunch with him in the judge's dining room in the D.C. Circuit, and he was well aware of all the criticisms of Chevron. I don't know what his final view was. I would defer to others in the room. But I think, one can believe that Chevron was right for its time, but believe that the incentive effects of it were perverse. Because I think what happened, in more recent times is the executive branch reads a statute, actively tries to make it seem ambiguous in order to basically impose its policy preferences on the statute, right? To sort of throw up monkey dust. See how the statute seems clear, but it's really not. Here's 10 reasons why it's not clear, and therefore we get to do what we want, and that would involve an aggressive reading of a statute. And of course, I think under Chevron, they could be rebuffed because the interpretation at stage 2 isn't reasonable. But in the interim, their view has had some purchase and has prevailed. And so, I think it's sort of like, the analogy would be sort of telling your kids you have some discretion and them abusing it, and then you revisiting the question later and thinking about the effects it had on the executive branch. I think the executive branch today is not the executive branch of 1984. I think it's deliberately distorting statutes to advance its reelection and policy goals in all kinds of ways. And that ought to matter in judging whether Chevron ought to be kept or not, because it is true that the president is elected and judges are not. But it's also true that Congress is elected, and Chevron is a presumption. It's not as if Congress has said in its statutes, we mean for Chevron deference to apply to any of these statutes. And if you believe, as I do, that the executive branch is monkeying with the statutes, then you have to think about whether Chevron's partially responsible for that.
Yeah, I guess I would just observe that in many ways, when Chevron sort of came of age, I think of Chevron as kind of a second best judicial doctrine. So if courts are not going to enforce the non-delegation principle and they're going to allow widespread delegations to agencies, then of course courts can't be filling in the gaps, right? Then of course, we have the point that Professor Barco made about, political accountability. But I think, and I think as long as the court is not going to enforce the non-delegation principle, courts will always have to, allow agencies to be the primary policy-making body, because courts, simply can't regulate the environment or clean water or something like that. But I do think it's a doctrine of the second best. And so in some ways, Chevron is not the most important thing. The most important thing is whether the court will fix the non-delegation principle. And I guess I would also say that I don't take Chevron to be a doctrine about courts deferring on whether Congress has in fact given an agency a certain type of power. So courts always have to still figure out, did Congress delegate this type of power or the scope of this power to an agency? And that question is not on one on which judges, I think, should ever defer. And I don't think Chevron requires them to defer on that question.
So just two things. So one, not everything from the 80s is bad, Cy, because like you two is still awesome. And they were awesome in the 80s and they're awesome now. But more fundamentally, I think that part of what the Supreme Court is doing with Chevron is trying to control the DC Circuit, because this nightmare scenario that you play out only happens if you aren't trusting the appellate judges on the DC Circuit and occasionally in other courts, to really adhere to, when a statute is clear, the agency just can't magically make it ambiguous, right? You actually have to take your step one obligation seriously. And I think that's one of the reasons why, Justice Scalia said he had no problem with Chevron, because I just look at everything at step one. Most things for him were clear because he didn't look at legislative history, and he did a textual analysis. And I think if judges were fulfilling their obligation under step one, some of the cases get resolved that way, and the agency can't just magically bring it to step two. But I do think there are real step two cases. I think there are cases where things really are ambiguous, and when that happens, I think it's as between a choice of two entities, it does make sense to let the agency be the one to do it. And I guess I would just say that I see this as about the Supreme Court trying to take greater control over these things, because if you make everything about statutes and it's all about that, that more cases that they disagree with will filter up there and go there. So I actually think it's a power grab with the Supreme Court trying to police the lower courts more than even before. Now, I don't know if Judge Silberman would have agreed with that or not, but if he did think it was a power grab, I think he would say something about it.
So I assume, Chevron might come up and be another topic on our administrative law panel later today. So for now, I'm going to turn us back to Morrison versus Olson. And one thing that I think is fascinating, I'd like to ask you all about, is that it seems obvious, thinking about Judge Silberman and his career, that his executive branch service at a very high level would have influenced his strong executive supervisory approach in that case. But intriguingly, when he was reversed in the 7-1 opinion by Chief Justice Rehnquist himself was also a key executive branch leader, also around the Watergate time. So do we have an idea about what it would be that was unique to Judge Silberman's either approach or ability to think clearly, I might say, maybe that shows my priors and bias, but about the issue when even his former executive branch colleague would have thought about it in the opposite way? Was that just the chief's role at the Supreme Court negatively influencing him? Why would two executive branch folks take such different views?
I think the judge had a theory that he propounded, when I was there. The theory was the chief took the case, in other words, he agreed with the majority in order to take the opinion himself. But then when he wrote the opinion, he wrote a really broad opinion.
Very
so that's
broad,
part of the argument. That's part of the argument that doesn't make any sense, right? Because you can imagine him joining the majority, writing a narrow opinion, but he wrote a really broad opinion. I suppose the other thing, which I don't think he mentioned, is William Rehnquist worked for Richard Nixon, right? Tricky Dick Nixon. And you might think that the independent counsel statute was really created for someone like him, and he might have still thought that was a possibility. Of course it is a possibility, right? And that might have influenced, the policy behind the statute might have influenced his understanding of the Constitution. And of course, it's not uncommon for policy judgments to influence constitutional judgments. I think that's probably the case for most of the justices in Morrison. They thought it made sense for someone else to look into executive wrongdoing. They didn't think it made sense for the executive branch to be able to police itself and not obviously do a very good job in so doing. So he had a reason, and then there might be, maybe Rehnquist is thinking about Richard Nixon.
I also think that Judge Silberman, in addition to his executive branch experience, had just the best political instincts for how things could play out in kind of a multi-layered chess game. If you try to think in the future, how might this work with different people and their incentives? I don't think that was a hallmark of Chief Justice Rehnquist. That's just not what his opinions were like, and he didn't care. The joke would be like, well, that case was about a train, and this case is about a car, because he would basically just think, if we get problems later, I'll just deal with them later, and I'll be able to distinguish them on pretty narrow factual grounds. Whereas I think Judge Silberman was definitely more committed to greater principles, and in trying to reason through those principles, had very good instincts about where the perverse incentives would be with something like an independent counsel law. And so he does have examples in there about, imagine the way in which Congress could use this going forward, like the ones that you cited that Justice Scalia had. Judge Silberman had those in his opinions as well. Congress can do this for, the Undersecretary of Agriculture, and, can kind of chip away. And so I think it's that that being attuned to where the dangers lie, but then also, and maybe Chief Justice Rehnquist saw those as well, but he would just figure, well, then I'll just deal with it in the next case. I think the other thing that's different about Judge Silberman is he recognized the unique harm in the independent counsel context, because we're talking about a criminal prosecution, and he was really very good at being attuned to the dangers of a prosecution and what that meant for someone's liberty, and Chief Justice Rehnquist was not.
Yeah, no, that's an interesting distinction, because Chief Justice Rehnquist was at the Office of Legal Counsel, which arguably is one of the offices most distant from the criminal process and anything like that at DOJ, whereas Judge Silberman would have been much more in a direct line to have to think about those issues. Judge Rao, did you have anything?
I guess I'll just say I absolutely agree with Judge Silberman and Justice Scalia's view of the case, but there are, in fairness, I think, to Chief Justice Rehnquist, there are some nuggets in the majority that I think could be helpful in the future. For instance, there's this idea that even under a for-cause protection, somebody can be adequately controlled, for the purposes of executive power. I think there are some, you can read Morrison v. Olson, the majority opinion, in a way to suggest that, yes, when an independent agency head disagrees with the president perhaps can fire them for cause, just because they disagree. And so I do think that if perhaps someone else had written the opinion, there may not have been some things in there that were helpful. I mean, again, I don't agree with the majority, but I do think that there are some things that are not often recognized as perhaps being helpful to the unitary executive, even in that majority opinion with which I don't agree.
Great, thank you all. And we're going to turn to audience questions here in a moment. So if you have some, get them ready. This is your chance. But before we do, as you all being close students of the judge's jurisprudence over the years, did you see any transformation or development or growth in his separation of powers jurisprudence over the years? Or was he writing opinions just as broadly or narrowly at the end of his career as at the beginning?
I mean, I got the sense that whatever he wrote, he was right. That didn't change. If I could just, say something about what the judge just said, and going back to Morrison, I think that the independent counsel statute reflected a certain set of concerns, and the court, I think, bent over backwards to accommodate them. I think some of the concerns expressed in Scalia and Silberman's opinion would have been felt on the Republican side at the time, right? Judge Laurence, what's the guy's name? The guy who was investigating Iran-Contra. Walsh. Yeah, Lawrence Walsh, was accused of being a runaway prosecutor. It's just that Democrats tended not to see it that way. It only mattered when the shoe pinched them with respect to Starr. So it wasn't as if they were, I think there seems to be a prescience to their opinion, but I think in fact they were maybe subtly talking about other independent prosecutors that existed at the time.
I mean, the judge became a little more freewheeling in how he wrote his opinions towards the end, which I personally didn't love. I will say I didn't agree with all of them at the end, not necessarily separation of powers, but and I think his writing style changed a little bit. I think there were more references to things that the media, just to think about the New York Times versus Sullivan decision, that I don't think he would have written at an earlier stage in his career. And I guess people can have differing views on whether that was a good or bad progression, but I do think it was different.
Judge Rao, his former colleague?
Yeah, I do. I think his style may have changed somewhat. I think there's a certain confidence maybe that comes from being on the bench so long. And I would sometimes joke, I'd get a draft of his, I'd be like, there are no citations here. And I would say, Larry, there are almost no citations. He's like, well, I'm the law, And, after so many years, perhaps, he was the law. He didn't need to cite a whole lot of things because he said it became the law. That was, enough, So I do think maybe there was something to, I kind of, respect that. I'm like, oh, at what stage can I just stop citing cases and just say things?
See myself.
Yeah, right. I think I have a lot of decades before I can get away with that. So,
I think he was always super confident.
Yeah, no. Right.
That's what made him so much fun.
Maybe his clerks became less nudgy about putting citations into his drafts, you know.
That's great. Well, this has been delightful. Do we have anybody who wants to ask? Oh, good. Judge Nichols.
Why don't I pose this to Rachel first, my co-clerk? Did the judge think Chevron was constitutionally required or just a good idea? And if the latter, why wouldn't he criticize it then?
I didn't see any place where he specifically said it was constitutionally required. Others may know of where, but at least the things I read to prepare for this, I did not see that. But I think the reason that he thought it was a good idea was for the reasons that I articulated, that there will inevitably, I mean, I get the argument that in an ideal world, I would like to see Congress do its job and pass statutes that make the hard calls and make decisions. And I know there are people who want to see Chevron overruled because they have some utopian vision that, oh, great, now Congress will do it. That's not going to happen because there's a million political reasons that Congress is going to want to punt on issues and leave ambiguity so they don't anger various competing interest groups. We can go on and on. And I think Judge Silberman recognized that political reality. And I think he recognized there will be ambiguity in statutes no matter what you do. And as between having an unelected judge decide what to do about that, or an agency that's part of the executive branch, that's part of a political structure that has expertise and can think about how the policy fits in with a broader perspective, that is actually a separation of powers concern because you're choosing between two possible actors to give an interpretation, and the better choice in that scenario would be the executive. But I do think that if, you know, he would probably agree in an ideal world, you want Congress to resolve as many of those things as possible. But, you know, we're a long way from there, and there's just no way that the court overturns Chevron because it thinks Congress is going to do more. I will happily take the bet with anybody in the room to see how that plays out. I do not think that will happen, that Congress will do more.
Ramon, and then we'll go to Viet.
Yeah, so two quick comments and a question. Thanks. So I think the ABA speech that Professor Barco was talking about is fascinating, a fascinating document, and really sets out his views on two issues that came up. Judge Nichols, on your question, he actually says in the speech that he does not think it's constitutionally required. The other thing that's interesting is on the step one question, he actually disagrees with Scalia, and he says he does not think that step one is actually going to resolve that many cases. So he kind of goes in the direction, he says most of the cases that he sees should not get resolved at step one because he thinks it's very hard. So I thought that the speech is fascinating. The question I have is, it does seem like the premise of his views on Chevron are exactly what Professor Barco laid out, in that the idea is that if there's ambiguity, then really you then become a policymaker and you're making policy, and agencies should make policy, not courts. It seems, though, that logic kind of proves too much. I mean, courts look at ambiguous constitutional provisions, ambiguous criminal provisions, and I think there's a much greater, I mean, I don't think anyone really thinks that courts should defer to agencies on what ambiguous constitutional provisions mean, and I'd be surprised if people thought that courts should defer to agencies when they're looking at, you know, they should defer to the Department of Justice when we're looking at criminal prosecutions. But so is there a tension there? I'm sort of curious to see whether that logic holds up in those other contexts.
I don't see any tension because clearly constitutional interpretation is for the judiciary. I mean, if you want to buy Marbury versus Madison. So we are talking about something different in terms of statutes and statutory ambiguity, and the criminal context is different in the sense that there is no deference to any agency. Case law makes that clear. But I do think it's interesting that there's a similar doctrinal lean, which is that if a statute is ambiguous, you're supposed to use the rule of lenity and the benefit should go to the defendant. And I think that it's a similar kind of policy assessment that says, okay, this is an ambiguous statute. Should we give the benefit of the doubt to the all-powerful government and its interpretation of what the criminal statute means? Or should we err on the side of individual liberty? And when it's not clear, we err on the side of the defendant. So I think it's not an accident that Justice Scalia was the best rule of lenity person on the Supreme Court, because he played that out very carefully when he talked about the rule of lenity. As between those two, you have to make a choice. And I think here it's an as between the two. It's between the federal judiciary and the agencies. You have a choice. You don't have the choice with the Constitution. We don't have the agency of constitutional interpretation, but you do in these contexts. And when you have the choice, there are good reasons to give it to the agency.
Although what's interesting about the rule of lenity comparison is Another way to think about it, maybe in the administrative law space, is if the default and rule of lenity is to think the government didn't act right because you don't want to over-criminalize your for liberty, would the analogous thing in the agency context be to assume Congress had not given over the power unless it was clear it had, rather than choosing between two different branches? But Viet had his hand up, and so I want to see, before we run out of time, what you wanted to ask the panelists.
Just one comment and a suggestion. Sometime in the 1990s, I proposed that the Ethics in Government Act be amended with one word to include insubordination in the definition of cause. And the judge agreed that would solve the entire constitutional problem, to Judge Rao's point. My suggestion is we give the floor to Sarah Jorgensen so she can defend the Chief Justice against the libel that's been committed on stage here.
That's great. Any other questions? Thank you, Viet.
I'd like to respond to your question about constitutional interpretation. There is a theory of constitutional interpretation that courts should not strike down statutes unless they're clearly unconstitutional, right? That's the Thayerian theory of deference. And you could have a similar rule for executive branch constructions of the Constitution that, where executive branch interpretations matter. So it's not that it's impossible to conceive, it's just that that's not our approach today. And it's not obvious that it couldn't become an approach in the future. It tends to be the case that when people don't like what the court is doing, they'll sort of offer that as a suggestion. But when they like what the court's doing, they seem to forget the idea.
So we have room for one more question, and then I'm going to give the panelists a chance to have a closing comment if they would like. Anybody a comment? John, you're usually never short on words. Do you have any comment for us? Okay. Just giving you, never lose the opportunity to poke a little bit at John, the great John Yoo. Oh, you do have a thought.
I always have a question.
Oh, good, great, excellent.
So I actually remember arguing with the judge about this our first week of clerking. Do you think the judge thought that Marbury versus Madison was correctly decided? Do you think Marbury versus Madison was correctly decided?
I mean, I think they misread the statute, so they didn't need to.
The answer is no. Those are the judges.
They misread the statute to get a constitutional question that they didn't need to decide, right? So there are many mistakes in Marbury. There's no doubt about that.
All right, well, that would unwind all of your, but anyway. So we're going to end big here. So any further closing comments on just Judge Silberman's legacy or what you most appreciated about your time working for him or with him?
I'll just say he was the greatest boss I've ever had, and a really wonderful human being. And this panel was about substance, and so I focused on substance. But to just take a moment to talk about Judge Silberman, the person, he was the embodiment of honor, character, honesty, just every good trait you would think you would want a human being to have. I never saw him act in any way other than just with he just carried himself so well in every setting with every person. He was just a really wonderful human being, and as great of a judge as he was, and I think he was outstanding, he was an even better person. And it was a true privilege to have known him in my life.
That's very lovely.
Rachel's 100% right. It was a pleasure and an honor to clerk for him. I can remember all the put downs and the jokes and the sarcasm, and I treasure each and every comment that he ever made to us. I treasure the time he spent with us. We used to have lunch with him all the time, and it was an unforgettable experience.
Judge Rao?
I mean, look, Judge Silberman was a giant. And as much as he understood about the law, I think he even understood more about people, which is why we all are so fond of him and are so grateful for the time we spent with him. I know, I feel like anytime I'd have lunch with him, he would look at me and say, "You are concerned about this." And he would always know what it was that I was concerned about at that moment or what was bothering me before I would even have to say it. So, and he sometimes about strange legal things would say, "Well, this is really a purple cow." Like I said, like there's never been anything like it. And, I don't know, maybe to me, Larry himself was kind of a purple cow. I'm not sure there's anyone ever there's nobody else quite like him.
That's really great. Well, the good news for all of you is we are just getting started here today at this conference. We're going to have lunch here in a couple of minutes with another set of esteemed speakers and former clerks of the judges, and then a couple more panels this afternoon. But I want to end by giving you all a round of applause. You all have been excellent. Thank you.
Silberman clerks, because it will be as if you all found a jurisdictional defect, because you're all going to have a free lunch now, as Rachel said. And then we're going to proceed to what the judge did to the former clerks. The judge loved to have lunch every day with his clerks, and the clerks would provide him with intellectual entertainment. And so that is what we're going to have in the next panel, to be led by Viet. Oh, there's Viet. Viet Dennis, who is going to lead the next panel, which is going to be personal reflections by Judge Silberman's former clerks and friends. And then I was remiss in the introductory remarks to give thanks, because I was just in my mind, the judge was always saying, get the show on the road. And so I was in such a rush in the introduction, I forgot to actually explain all the people that we should thank for this event. And so let me just do that very quickly before lunch. First, Robert Dorr, the head of AEI, who fell in love with the judge, as many people did, and we had a special program with him at the AEI Jackson Hole event last year. Yuval Levin, who heads the Constitutional Studies program here, has been an invaluable supporter of this conference. Adam White and Jen Mascott, who planned the conference with me. Nicole Penn, where's Nicole? Nicole is the manager of the constitutional program here, and the judge would have loved her, because she actually makes the trains run on time here at AEI. And Camilla Hergis, I don't know if she's here, who actually you might have met out in the front when you checked in. She also helped with the program. But most importantly, I want to give thanks to the Silberman family, Tricia Silberman, who is here. I know Bob Silberman is coming later. I don't know if I saw either Katie or Annie's here. Oh, there you are. Hi, Annie. I haven't seen you in years. How you doing? So thanks so much to the Silberman family for allowing us to celebrate the judge's life and career in this way. And so enjoy your lunch. Talk about jurisdictional defects. I think I'm the chamber's record holder. I found 3 in 1 year, although the judge claimed one of them was just I browbeat the parties into settling so that they wouldn't have to be arguing about jurisdictional defects. So see if you can find more than one over lunchtime in any case ever before the Supreme Court that should have been dismissed for a jurisdictional problem. And thank you. Get your food, come back in 15 minutes, and then we'll start with Viet's program. Thank you very much.
Well, of course, my notes are written backwards. So good afternoon. Please continue to eat, but please do so quietly, if that's possible. We, unlike the rest of the academics and scholars today, we are unabashedly personal for the luncheon discussion. That is, we will remember the man, the judge, the mentor, the civil servant, everything about Judge Silberman, and not talk about Chevron or Morrison v. Olson for about 45 minutes or so. With me is obviously part of the Silberman family. I'll start first by introducing everybody, and then we'll just get into a conversation. And toward the end, please do join in, because obviously we are all part of the Silberman family. Brent McIntosh is the clerk for the judge in 2000 and 2001. He's currently the Citigroup Chief Legal Officer, and formerly, obviously, the Undersecretary of Treasury for International Affairs, as well as General Counsel for Treasury. He was previously a partner at Sullivan & Cromwell and the living embodiment of the Washington revolving door, which the judge loved so much and always extolled throughout his career. Sarah Harris, the clerk for the judge and also for Chief Justice Thomas, is a partner. Oh, okay. Clerk for, she's now a partner at Williams & Conley, and like John Yoo and so many others who went before her, was a Deputy Assistant Attorney General at the Office of Legal Counsel. Interestingly, and I hope that she'll return to this later, I'll ask her to return to it later, she has a PhD as well as master's in history, having written a beautiful volume on the history of the CIA. Jean Scalia is the partner at Gibson, Dunn & Crutcher, obviously, famously, the former Secretary of Labor, as well as the Solicitor of Labor, a post that he proudly shares with the judge. Gene is here because he is not a law clerk for Judge Silberman, but he is what we call either a non-clerk clerk or more properly an honorary clerk. The judge, being the magnetic personality that he is and such a warm mentor and such an available and generous spirit, attracts young men and women, even those who did not clerk for him, and freely offer his advice and guidance, even when unbidden and unprompted. But a number of these have been so welcomed and have welcomed themselves so well that have become a part of our clerks family. Gene, of course, is their leader, but people you know, John Manning, Chris Landau, Miguel Estrada, and so many others. Some of you are here in this room.
Roman Martinez and Dan Carney.
Of course, Roman and Don and Dan. So everybody, we are a big tent. More importantly, a big tent with a very, very patient and wonderful patriarch. So maybe I'll start there, Gene, and ask you to share some thoughts, because you seem to have copied the judge's career pretty well up to this point.
Thanks, Viet. It's such a treat to be here. I'm really honored to have been included. And the judge, of course, had many gifts. One was, you've already touched on it, a gift for friendship. He was extraordinarily warm, very funny, and attracted, as Viet said, so many other wonderful things, people around him. One of the gifts of being his friend was the other people he would introduce you to, and I'm seeing many of those people today, and it's really a delight. And of course, he was also, to those people, a great source of advice and counsel, too. And by the way, one of my father's very, very closest friends from the days they worked together at the Justice Department until my father's death. And I still recall the day about a dozen years ago when I called the judge because I felt we needed to speak to my father, give him some advice together. And I said, Judge, my dad's eating too much and not getting enough exercise. It's just, he's got to lose some weight. And the judge said, yeah, it's true. Let's have lunch with him. So, and so we sat for lunch and we chit-chatted, and then my father looked at us and said, all right, why have I been summoned here? And so I looked to the judge as his old friend and as my mentor too. How do you approach this it was a sensitive moment, but the judge, he knew how to handle these things, and he looked at my father and he said, "Nino, we're here because you're too fat." Discussion ensued. As Viet alluded, I was Secretary of Labor. I was honored to have that job in substantial part because it was a job that Judge Silberman had, and I thought any job that he had and loved was an honor to hold. And so that's part of the reason that I came to have the job. But as I reflected on it, I feel I performed that job well, but I feel I did that in substantial part because of the path that he had laid down as solicitor. He was beloved in that office. And when I showed up, there were still people who'd worked with him and admired him. He was, by the way, a vigorous supporter of the Labor Department's independent litigating authority. Unlike a lot of departments, the Labor Department litigates a lot of its own cases, but there tends to be some tension sometimes with the Justice Department, and there are gray areas. As solicitor, and then he was Undersecretary of Labor too, he fought hard to keep cases at the Labor Department. Was very effective, but then of course he eventually left the Labor Department. And not long after that, a really big row developed between the Labor Department and the Civil Division of the Justice Department about this independent litigating authority issue. And I learned from my staff years later when I came that the Civil Division lawyers said to the Labor Department lawyers, we're at impasse, we're going to have to take this to the Deputy Attorney General for resolution. And they figured, they've got it all figured out at the Justice Department. But of course, the Labor Department lawyers knew the judge's the passion of the Deputy Attorney General for the department's independent litigating authority, because Judge Silberman was now the Deputy Attorney General. So they walked in, to lay before him all his prior arguments, and they just got shellacked. He rejected everything, gave all the authority to the Justice Department, and they're beside themselves. And they confronted him. They said, "Judge, what are you doing? This is totally inconsistent." And he said, "No." That deadpan expression he would have. He said, "No, I'm totally consistent. Where I am is where the litigating authority is." And that was the resolution. He, as labor solicitor, and I would hear this from the people who had worked with him, he engaged with the work of the office with the kind of intellectual brio that we all remember and love him for. He managed it vigorously, reorganized the entire solicitor's office. The organization it has today is the one he gave it, made perfect sense. And he engaged very personally with the staff who respected him. Some of them loved him, admired him, and maybe feared him a little bit. But he was a great leader, and a lot of people talk about how can you manage in the deep state. This was Nixon's top labor lawyer, winning and leading and the affection of the staff there at the Labor Department. For me, it was a really...
Don't overstate it. He did author affirmative action as far as
I did not say that his career was flawless or that they did not at times lead him to error, which he was very proud to claim credit for years after. But he was a great model of how to manage that office. And they used to say there were 4 good solicitors and that he was one of the 4 good solicitors. In fairness, I should say that one of those other 4 good solicitors and somebody else that was very important to my career at the department was Bill Kilberg, who had been solicitor and also worked with me at Gibson Dunn, but himself had been mentored by Judge Silberman. Toward the end of my tenure at the Labor Department as solicitor, an issue arose that I was very challenging. I thought might require me to leave the department. And so I brought this to the judge, and we talked about it over a period of weeks. And he agreed that this could be something that would warrant your leaving. It was a very challenging time for a couple of months while I worked this through to decide what was the right thing to do under the circumstances. I was so grateful for his advice and counsel in that time. And both because I ended up believing, based on his advice, I did the right thing, but also I will never forget that it was enough to me that I had his approval, that the judge believed I'd done the right thing. That, to me, was confidence that I had as well. And 15 years later, the judge swore me in as Secretary of Labor. And he and I talked about it afterward. We both believed that it was decisions I made as solicitor with his advice in the manner of how I handled that dilemma that I had at the time, which made it possible for me to become secretary later. So I was so grateful. So a lot of the program, I gather, is focused on the judge. As a judge, I will always call him judge, by the way. I will always call him judge, by the way. But, I actually think of him more in association with the executive branch. I think of the judge as a student of history, as a student of presidential administration, and as a student in part of how people in government should comport themselves. I will tell one last story about the judge. It's not actually true. But who is he to complain about a story about him that's not entirely precisely accurate? It's the story that my friend Paul Capuccio, many of you know, his imitation of Judge Silberman. It went like this. I was there. I was there in the room. I said, Harry, you've got to drop the bomb. The judge was a student of presidential administration, decision-making, comportment in government, really throughout the time that I knew him, that so many of us knew him, and so thoughtful about what he called honor, how people should behave. He was a man of principle. We can say that about a lot of people, but he showed us how to be a person of principle, and so many of us are indebted to him for that, and the country is too.
Yeah, very nice, Gene. We'll come back to you, but what you said about his favorite sayings about I was there. Last week I was in a deposition prep where I was a deponent, unfortunately.
We've heard from you.
My lawyer asked me something, some hypothetical. If the allegation was false, would you do a retraction? I don't know what case is all about, but and I immediately responded, if my aunt had wheels, she'd be a trolley car. And like 6 very well-educated and very highly compensated lawyers just looked at me and said, "What the fuck did you just say?" And I said, you didn't clerk for Judge Silberman. And I was comparing notes with another friend, Paul Clement, who'll be here later. And I said, give me some Silbermanisms. And he says, he was my classmate. I say that because Sally is here, and she reminded me that her beloved husband, Tim Dyke, was indeed the judge's classmate. And so, needless to say, his circle ran wide and also ran deep. Sarah Harris, you obviously share a passion with the judge in history and the history of espionage. There's so many other angles I can take this, but let's start there.
So I cleared for the judge, and what I gathered from the previous panel was his metaphorical hair down stage. Of course, no actual hair at that point, but metaphorical hair down when he was perhaps a little more loosey-goosey, and I was hired, I believe, on the strength of an email that described me as a blonde national security hawk with an interest in the Cold War, a probably narrow demographic. But I had done graduate work on the history of the Cold War, and it really was the start of a wonderful relationship, just sharing our interest in that era of history. Of course, the judge, one might think, had lived through portions of it very personally, not so much for me. But trading book recommendations, and I remember just so distinctly, even up until right before he passed, he breaking news said, I've reconsidered my views on the Roosevelt administration. I was like, Judge, what's going on? Like, what are you talking about? And he said, I read this biography of Admiral Leahy, who is Roosevelt's chief of staff, and it gave him a new appreciation for the Roosevelt administration. I did promise, not to tout this widely because who knows what one would think. But that was the kind of thing we shared. Just how was World War II won? How was it waged? And how do people in government who did not do it sort of for the glory or the headlines, and Admiral Leahy is a great example of that, conduct themselves? And it just sort of returns to something Gene said too, which is a lot of folks from that era in particular, you think of the price they paid of government service, the weight of being in a period where nuclear war was a very real fear for everyone, and the psychological toll, as well as a lot of headlines. And so I think that was something we shared, and then bled into the idea of government service as something where you have to do it honorably. And certainly when I was in my lowlier position than these folks, but any position you sort of had the judge as the voice in your head thinking every day, are you doing this the right way? And also, are you paying attention to how your component, your department is managed? And what will come down the pike. So, I mean, I felt really blessed to have that bond with him at the outset.
Yeah, so I remember very early on in my clerkship, the judge said to me, in order to make a brilliant young law school graduate into an excellent lawyer, you need to get him a spouse and a mortgage. Apparently, he said that to you and Jeff also.
So Jeff and I are the only Silberman clerks who ended up marrying each other. And I met my husband at a Silberman clerk reunion, which turned out to be the best place to meet your spouse. First of all, I think we're the only single people. And second of all, it was as if we had been pre-screened to have things in common. So that was great. I was an anticipatory clerk, Jeff was a former clerk, and I think the judge had really given up on the idea of his clerks marrying each other because it was fairly late in his tenure, and as he'd like to say, conservative women are as rare as hen's teeth. So the odds were not in his favor. And by that point, I started clerking when Jeff and I had been dating for 2 months. The judge did his sort of wind up and said, is there anything else I should know about you? And I said, I'm dating one of your former clerks. And his eyes lit up. I think he was also really jealous of now Justice Kavanaugh, who had the luck of having 2 of his clerks marry each other his first term. The judge had been waiting for so long. Every Monday I came into the clerkship, the judge would say, has Jeff proposed yet? And I would say, Judge, we've been dating for 2 months. And he said, stop wasting daylight. He said, he's like, I proposed to Ricky after 1 dance and Trisha after 1 date. Stop wasting daylight. And so, Jeff and I got engaged after 5 months, which many people thought was fast, but not the judge, because immediately after I told him, he called up Jeff and said, what took you so long? And so the judge sort of not only thought it was important to have a spouse, but obviously, the judge was very special to us, performed our wedding. He ad-libbed a little bit, as one can imagine. And then was very close to us, sort of throughout. We would take him out to lunch and see him repeatedly. Of course, every time we went to lunch, the judge would say, why are we meeting? You're having a baby. And invariably, the judge would be right. Years later, we finally had a boy. And this is a testament to how much we love the judge, which was that we bestowed on him the middle name of Laurence. And we were just very gratified that it was 2 weeks before the judge passed away and that he was delighted that his name would be carried on. So lots of grand clerks and lots of memories with him.
And I know that he, as you mentioned, officiated your wedding, which was, all kinds of pleasure and honor for him. Well, how was it?
Well, the judge let off the vows by saying some marriages are mixed marriages. This is not one. The bride and groom are both Republicans. And then he just did the regular vows. We did assume the risk.
But also the entertainment.
That's right. It was lovely. I mean, really, really special for the judge. So.
Yeah. Brent, you share with him your the love of the law, but also your love of the Second Amendment.
Yeah, well, that's entirely true. I have to say, when your recommendation for the judge sounds like a better one than I got. Mine was I walked into Chambers for my interview, and he said, Brett Gary claims you're a reactionary. And I stumbled around a bit, and then he said, great, you've got the job. And that was the start of an unconventional relationship, I would say. He was, the judge was an extraordinary man. He was an extraordinary mentor. And when I say extraordinary, I mean not just in the sense of exceptional, but I mean also in the sense of unconventional. There was nothing about clerking for Judge Silberman that was typical of a federal clerkship. There were no bench memos, as the clerks recall. Instead, your job was to learn the case inside and out and then to go argue the appellant's case to the judge, whereupon he would berate you for how bad your arguments were, and then to argue the appellee's case to the judge, whereupon he would berate you for how bad your arguments were, at least for me. And then you would watch him do the same thing to very highly paid counsel, and you'd see them blundering down the same path you'd blundered down, and it was at least gratifying in that sense. The clerks always had very unconventional duties. Rachel alluded to one of them earlier, the duty to to figure out whether there was jurisdiction for the case, regardless of whether the parties had raised it, and get a lunch if you could identify a jurisdictional defect. The lunches were always a key part of being with the judge. He would assign a banker among the clerks. You probably recall this. The bankers were routinely fired for overcharging the judge for lunch. And so it rotated several times through the course of the time you were with him. I clerked for him during Bush v. Gore, and so I had a month during which my only job was to know the latest development in Bush v. Gore. I had no judicial clerk duties other than that. He also, for those of us who clerked for him when he had a boat, would come in and apologetically say, tomorrow we have to go out on the boat. And he thought that this was a real imposition because you were there to learn the law, but you'd show up the next day wearing boat shoes and shorts and go out and spend time on the boat with them. And those were the most delightful days of them all. He did claim, in fairness, that the primary contribution I made during my clerkship was teaching a particular knot on the boats, tying the lines, which I'd learned as a Boy Scout. So not much of a contribution. I also had the duty of figuring out whether his class at Harvard Law School had the most judges, Article III judges drawn from it. And at the time it did. It was subsequently, I believe, replaced by a class from the University of Michigan, which is disturbing to him. The scope of his mentorship was not limited to the professional. Indeed, it was not primarily professional. It was often very much personal. His primary advice, as Sarah has adverted to, and Jeff knows well, to us, was to come in every day when you were dating someone and say, "Why haven't you proposed yet? She's going to find someone else." My wife did not find someone else, so I've been very fortunate. And then when I came back to him after a weekend where I'd proposed and she had accepted, I came back and proudly said, "Judge, I proposed." And he said, "Geez, it took long enough. Let's get back to work." He also gave a lot of sartorial advice, which was interesting coming from a man who would wear a cravat. He had views on everything. Which Senate Democrats could be trusted to keep their word, Ted Kennedy, and which could not, and that confidence will stick with me. He had views of the relative merits of various college football programs. University of Michigan, always overrated in his view. The Ivy League, always underrated in his view. He had views on law schools. Yale, overrated in his view. Harvard, underrated in his view. How many days a clerk needed off to take the bar? 2. It's a 2-day exam. He, most importantly, had views on the constitutionality of the laws prohibiting smoking in federal buildings. This was an as-applied challenge. It was as applied to judges' chambers. The holding in the matter was that the separation of powers prevents the Congress from preventing judges from smoking cigars in chambers. After I clerked for him, we began having weekly lunches at the Metropolitan Club, which were really, I think, the highlight of the week for a lot of us. Some of the people who were at those lunches are here. The judge would we'd have wide-ranging conversations on a whole variety of topics. He would routinely, when you tried to say something discreetly and in a low voice, say, "Speak up!" and then explain that as ambassador to Yugoslavia, it had been explained to him by the CIA that the best way not to be overheard is to speak in the same volume that everyone else in the room is speaking at, which I think was maybe true, but definitely good for his hearing. The lunches featured us placing a number of friendly wagers. Some of those wagers have not been collected. I actually have the last of them in my pocket. And they will not be resolved until the presidential election this year. He refused to wager on matters of national security because he didn't like anyone betting against the United States, which I appreciated. He could tell the same stories over and over, and they were fascinating every time, whether it was inventing affirmative action, reviewing J. Edgar Hoover's files, stories of Marshall Tito, the October surprise, his spats with Judge Mikva. But just when you thought you knew all of his stories, he would trot out a new one that you'd never heard, some jaw-dropping new anecdote you haven't heard. And it was extraordinary how the stories that he thought were not even worth repeating were more interesting than 90% of the stories anywhere ever had. But on the Second Amendment, he and I eventually became hunting companions. We spent a good deal of time hunting pheasant and partridge out in Virginia. He would drive, I would bring the sandwiches. The drives out and back were really the best time. I'd show up at his house at 7:30 in the morning, and we would, on a Saturday, and you'd make bacon, and we would drive out, and we would have these intense conversations on the drive out. So intense that at one point we were stopped by a Virginia state trooper for going a lot over the speed limit when he was driving. I will say, I think it was only a coincidence that the judge, in looking for his license and registration, also managed to find his judicial ID. And then explained to the trooper that because he was wearing very heavy hunting boots, his foot was completely insensitive to the pressure it was applying to the accelerator. Whereupon the trooper said to us, "Your Honor, slow down." We were also hunting one time, and the guide we had with us had learned that we were from Washington, D.C., and said, some of these judges, this was shortly after the Obamacare decision from the D.C. Circuit, some of these judges are saying that Obamacare is constitutional. I think that's crazy. And the judge later looked at me and said, "I felt very fortunate. I'm the one holding a shotgun." He was a great shot, even to the end. He was exceedingly generous, unduly so, in his praise of his companions' shooting capacity, and very frankly optimistic about his own. The number of birds we reported hitting was exceeded by a great deal the number of birds that regarded themselves as being hit. But it was an immense privilege to spend those times with him. When you think about the quantum of people who were influenced by his mentorship, it's truly, his contributions to the law and also to the lives of his friends is truly extraordinary.
Yeah, truly. Looking at you all here, and especially Gene, I'm reminded of children and what an important aspect of our lives and his life is family. Thank you, Trish, for being here. I know that you both are great parents, and I love to see all of the children here. I do think that him being a father and a good mentor has a lot to do with why we're all such great mentees of his, because in many ways we are part of his family. He cares about us just as he cares about his children. He models his parenting of us like he parented his children. So much so that Jennifer and I now model raising our three boys and girls on Rob and Tina Silberman's example, because these things get passed down from generation to generation, and I would be remiss not to comment on the domestic aspect. On the dress code, we were allowed to dress down on the weekends. That is on Saturdays. I think our third co-clerk, Dan Marin, was very proper because he's always golfing, so he has a very good country club outfit. Cy and I were not. We were roommates together, and we show up in chambers on Saturdays dressed like each other. That is shorts and T-shirts. Upon which, after the first Saturday, the judge came in on Monday, declared that there is a dress code now on the weekends. Which made the summers very, very intolerable. Should we open it up to more comments and contributions, or any more further reflections? I know that we all served in government largely because of Judge Silberman. One of my proudest moments, and I said this to the judge, and he was so grateful that I shared it, but also very proud. After 9/11, the first congressional hearing of many that Congress hauled John Ashcroft up to was going to be very, very contentious. And so there assembled in the Attorney General's conference room a coterie of lawyers in order to prepare him for all the novel constitutional issues, as well as all the political potshots that will be leveled at him. John Yoo was there, Paul Clement was there, I was there, Jennifer Newstead was there, Brad was there. But the import of this, and so many others, but the import of this, at one point I counted the people in the room who was there in order to prepare the Attorney General to defend the Constitution before the U.S. Senate. And 7 out of the 9 people there were Silberman clerks. And it was just such a proud day, and I know that John Ashcroft felt very well served, not only by the advice that he gave, but by the judge through the derivation. You want to say something, Gene, about public service?
I was going to maybe supplement what you said about the judge and family, and he was also for me a model of how to love and honor a wife. First with Ricky, and the way that he supported her, enjoyed being with her, but then with Tricia, and he was a gentleman in that way, and was a model to so many of us in that respect too. And I didn't want that to go unmentioned.
Yeah, very, very, very much so, and hopefully model how to treat a husband, Sarah. Jeff, you want to have a rebuttal? We have outside some reprints of the Harvard Journal of Law and Public Policy. A number of us wrote tribute for that. They are a very nice collection of essays, especially pointing to an oral history project that NYU did with Paul as the interlocutor and the judge and the life and history of the judge. I highly recommend it. It's available, and you can literally hear the great man's voice. And whenever I get down, I turn that on. It's better than therapy. So I could honestly recommend that to you. And with permission of Harvard, I think AEI will reprint that volume as part of the symposium volume from today. So with that, may I open it up for further comments and remembrances? This is group therapy. one year later. Judge Nichols.
I hadn't really been thinking about telling the story, but I am definitely in the unique position of being the only judge who was on a court below Judge Silberman, having clerked for him previously. And unfortunately, we didn't overlap for that long. But as you can imagine, he was on a panel in a case that was appealed to him. And I've learned that it's not great for the psyche of a district court judge to follow your cases as they go on appeal. Cases change, litigants focus on different things. Perhaps the court thinks you got it wrong. But there's this one case, and I'm sitting in my office, and I hadn't really been paying attention to it, and I get a phone call from Judge Silberman because the DC Circuit had issued its opinion in a case appealed from something I had done that morning, and he was on the panel. I hadn't read it, didn't even know it had happened. And the conversation essentially went something like this. Carl, that case that you almost screwed up, you're really lucky I was on the panel because I saved it for you. There was a possibility we were going to go off on the wrong tangent, but I made sure we kept it right, and so I'm just glad that you got affirmed. And I of course don't know if that's true. But to me it sort of suggests a couple things or is consistent with a couple things about him. First, he cared a lot about me. And I think one thing we can all say across our careers and our lives is about how deeply the judge felt about each of us who we were lucky enough to have clerked for him. We had this incredible relationship with him. And so he cared a lot about me and how I was going to react, I think, to it. I think he was also very protective of me. Again, I don't know if the story is exactly as he articulated it, which I'll get to in a moment. But I do think he was protecting me in his own way. And then the last thing I'll say is, one of the things I loved about him, and of course I don't know what really happened there, is he may have had an outsized view in that circumstance of his role. Because there are 3 judges on that panel, and they voted with him, and somebody else wrote the opinion. So So I'm not sure that he actually steered them in the direction that he did. But he wanted me to think that, and I actually appreciated it very much. And that was one of the last times that we interacted in a sort of professional relationship sense. So it was a very, very nice call.
Thank you, Carl. And that reminds us reminds us how deeply proud that his clerks become judges themselves. I know that he feels deeply about you, about Dave Namias and Steve Collison and others. We'll come back to you in a minute, Dave, to share how your judging was affected by your experience with the judge. But before that, Sally Katzen, who introduced the judge to the great Tricia. Thank you. We owe you doubly.
Absolutely. That was a great pleasure, actually. Tricia was a college classmate of mine, and Larry was a law school classmate of my husband. So what else could we do? But at Tricia's urging, I would just mention that if we're talking about the judge outside of the courtroom, he was also a teacher. And he taught ad law, and some of his clerks had helped him with the syllabus and the preparation for his classes. And then at some point, for some reason inexplicable, he asked me to co-teach at Georgetown the ad law class. And we thought it was kind of a nice thing. We had boy, girl, liberal, well, actually conservative, liberal, if I'm going to keep in the same pattern, Republican, Democrat, judge, practitioner. And so we were able to sort of mix it up a bit. And we were very proud of the back and forth that we were able to deliver in this class until the evaluations came in. The student evaluations. One of the worst decisions ever made by any academic institution is to allow the students to evaluate the professors. But in any event, what Larry took away was that I got all the compliments for my attire. I was well dressed, I was well presented, I was well outfitted, and nothing was said about his sartorial splendor. He was devastated.
That's excellent. I taught the class behind the judge after he teaches, because we both have a large section, and every single time I have to remind the judge and the swarm of students who are there to get additional knowledge to take it outside, because my class is about to start, and I'm equally as wise and important as he is. But no, never. Every single time he eats 15 minutes instead of 10 into my lecture, because he's so popular, and everybody just wanted to more from the great man as the great professor. Dave Namias, the former justice of the Georgia Supreme Court. Do you have any thoughts about how your judging and your career was affected by his judging and his career?
As John just said, I didn't know the questions would be coming to us. But, the judging part, I think, is probably the same for everyone who's a judge who clerked for Judge Silberman, that just watching him in action, doing what he thought was the right thing under the law, and the advice he gave, which actually was just as important in all the other public roles I've had, was really, you've got to do, what's true to you, because it's all going to come out publicly at some point, and you're going to need to be able to defend it in the way you could tell your mother or your wife and feel confident about it. And I think that is, I've given that advice to 1,000 other people as I've gone along. But I'll tell two stories that pick up on themes earlier. One on Rachel's. The judge loved saying that he hired me when I was a Democrat, and he would tell that story all the time, including when he came to swear me in as the Republican-appointed attorney, U.S. attorney in Atlanta. And, I told him, I'm not a Democrat anymore, and he said, well, I still like telling the story. So, And the other story to pick up is when I had been hired to work for him, my late wife was at Harvard with me, and I wanted to get engaged, but I'd been told, you better make sure you can take off enough time to get married. And so before I actually popped the question, I called Judge Silberman to get his permission to pop the question so that I would have time off. And as said, his reaction was, of course, what's taking you so long? And then to just pick up on a point that Trish raised last night, when I lost my wife, my last conversation with the judge last summer is when I called him to say I was leaving the bench and get his advice about that, because you call him even at my age to find out what I should do next and what he thinks about it. And I told him I was getting remarried, and he had a delightful reaction to that and told me how happy he had been in finding somebody else to lead the rest of his life with. And so, that is truly, he is, I've had great mentors, including Gene's dad, but nobody is a mentor like Larry Silberman.
Well, on that note, I think we're going to end this panel. Thank you very much.
that's not done. Yeah, don't bring it up at all. No, don't bring it up at all. All right, if folks will settle in, we'll get started in just a couple minutes. Oh, by the way, guys, that camera up there is the live stream camera, in case you're curious.
Which one is the live stream camera?
It's the one.
These are the true fans.
I was going to say, yes, they're the real diehards.
Okay. Oh, well, welcome back, everybody. And I just want to introduce Adam White, who's going to lead our third panel. Adam has been really crucial to the planning of this conference. He had a wonderful, I don't know if people saw this, he did a wonderful interview of Judge Silberman last summer at the AEI Jackson Hole Conference. Adam is going to lead this panel on Judge Silberman and administrative law. Adam's a senior fellow here at the American Enterprise Institute. And actually, like all three moderators, we all clerked on the DC Circuit together. He clerked for Judge Santel. And he's also one of the co-heads of the Gray Center over at George Mason Scalia School of Law. So Adam, also let me just say thank you along with Jen in planning this conference, and take it away.
Well, thank you, John. Nobody's thanked John yet, I don't think, but he really is responsible for doing this today, and we're also grateful for that. And also grateful, again, to the Silberman family for being here today. And I should also add many, many thanks to Viet Din and Jean Scalia, Brent McIntosh, and Paul Clement also for helping to get this going. It is a little risky talking administrative law right after lunch. That's why we make sure we have coffee ready, and we actually insist that people drink coffee through the conversation. Now, I will say, in defense of administrative law, there always is sort of an apology implicit when talking about Silberman and Judge Silberman and administrative law. I think it was maybe John who put it at first, early in the day. You know, he was on the DC Circuit doing administrative law in between the breaks from the really interesting things that he did. And of course, Judge Silberman, given all the things that he did do, and it happens to be true, I guess. But I want to say a word briefly before I introduce our guests about Judge Silberman's career in administrative law, because when you look through the oral histories he's done, the great oral history with Paul Clement for NYU, and the longer oral history with the DC Circuit Historical Society, he touches on his origins in administrative law. He explained, I think it was to Paul, that when he went to Harvard Law School, he was most excited to take labor and antitrust law with Derek Bach. And then in the other oral history, when they asked, what was your favorite class at Harvard? He said it was Louis Jaffe's administrative law, and also Hart and Sachs federal courts and legal process. Of course, when he graduates, he goes on to practice administrative law in the best way you can in Hawaii, doing labor law. And he told Paul Clement in that oral history that the first case he ever argued was a really major labor law case in the Ninth Circuit, although after the lunch talk, I do wonder how major the case really was. But he was obviously very fond of it to discuss it in the history. He goes on to be Solicitor of Labor, of course, and Undersecretary of Labor. And then after that goes to Steptoe and Johnson, where he thinks he's going to practice labor law, but he says it becomes a much broader general administrative law practice. And after that, of course, Deputy Attorney General, Ambassador to Yugoslavia. And then after the 1976 election, he comes here to AEI, not this building, we were in an earlier building. But he, as he often described it, he was part of the Ford administration in exile at AEI. He came here with Robert Bork and with Nino Scalia and others, Irving Kristol, Walter Burns, and others, where they spent a few years together, or I guess maybe Silberman was here for only a year or so, but they spent a few years working together through AEI, researching, writing, talking, all having lunch together, not just the lawyers, but others talking about everything from regulatory reform and law and economics to religion. Irving Kristol talks about this in one of his memoirs. While he was here, he wrote an essay that we also have reproduced out on the desk. It was an essay titled, very understated, "Will Lawyering Strangle Democratic Capitalism?" And in 1977, he writes an essay really grappling with the political culture of modern litigation, the effects it had on the economy, on our politics, and urging reforms. Years later, he gave a talk at the Federal Society conference where he explained how impactful this essay was. He said it spurred all sorts of responses. He was very, very proud of it. But it was a really fascinating sort of reflection on not law per se or even regulation, but just what kind of a country are we when litigation becomes such a driving force of our economy and our politics. Well, this year he also did a great panel discussion with Scalia in 1978 titled An Imperial Judiciary, Fact or Myth. And it's on YouTube, and you can actually see Silberman and Scalia, and I can't remember his name from the ACLU, grappling with what became really the debates around originalism and the Supreme Court. And of course, Morrison and Forrester to set up their office in the Croker Bank. He taught administrative law at Georgetown and Harvard, and as Sally mentioned, at NYU. But most famously, President Reagan puts him on the DC Circuit in 1985, where administrative law becomes the stuff of his day-to-day life. And he mentioned in one of his oral histories that Bork tried to talk him out of it, that Bork said he'd find it all far too boring, because of course Bork was often very bored on the DC Circuit. But he said Nino talked him into it, because he knew how much Judge Silberman would like the substance of the DC Circuit's work. And I'll just say, I didn't mean to go on so long, I'll introduce our speakers, but I do think in many, many ways, the way Judge Silberman worked and thought through administrative law exemplifies really what made him a great, great judge, not just in the way he saw the law, but in the way the principles that undergirded it. I didn't mean to go on so long. I want to introduce our two guests. First, one of Judge Silberman's final colleagues on the court, Judge Justin Walker. Judge is a circuit judge on the DC Circuit. He was appointed in 2020 by President Trump. And before that, he was a district judge on the Western District of Kentucky. Before that, a professor of law at the University of Louisville, an associate at Gibson Dunn, and he clerked for originally Judge Kavanaugh on the DC Circuit and then Justice Kennedy on the Supreme Court. And seated next to him is Aaron Nielsen. Now, when I invited Aaron to speak on this panel, he was a professor of law at BYU and of counsel at Kirkland & Ellis. But as of about 5 seconds ago, November 13th, he's now the Solicitor General of the state of Texas. Attorney General Paxton announced his appointment last week. When's your first Supreme Court oral argument as SG?
January 16th.
Okay, well, we'll try to keep this quick then.
I'm writing the brief over there. So,
Aaron clerked for Judge Jerry Smith and Judge Janice Rogers Brown and Justice Alito. And he's here today first and foremost because he's one of the leading scholars of administrative law today and also one of the leading chroniclers of the DC Circuit at the Yale Journal on Regulations blog, where he's been covering the DC Circuit for years and wrote a really nice remembrance of Judge Silberman on his passing. So I thought maybe we'd start with Aaron. You can talk a bit about Judge Silberman on administrative law, and then we'll turn it over to Judge Walker. And by the way, Professor Alan Farrell, a former Silberman clerk, very much wanted to be here today and was planning to be here, but illness kept him home in Cambridge.
All right, I'm going to start with a quote. This is one of the more obnoxious quotes about administrative law, not from Judge Silberman. This is from Justice Frankfurter and Universal Camera talking about the Administrative Procedure Act. And I'm going to set this up. You'll see why Judge Silberman comes into the story in a second. This is how Justice Frankfurter describes the APA. It is fair to say in all of this that Congress expressed a mood. And it expressed its mood not merely by oratory, but by legislation. As legislation, that mood must be respected, even though it can only serve as a standard for judgment and not as a body of rigid rules assuring sameness of application. Enforcement of such broad standards implies subtlety of mind and solidity of judgment, but it is not for us to question that Congress may assume such qualities in the federal judiciary. Which is a way of saying that the APA is very poorly written. Like, what kind of statute is that? My students read that, a mood? What does that even mean? And there's lots and lots of holes in the APA, but because it's so foundational, nobody will ever touch it or fix it or update it. But it's frustrating when you teach students the APA because certain basic things about how the world is supposed to work are not very well set out at all. And that brings to Judge Silberman. I was clerking for Judge Brown, and there was a case, and the case was something about like the flight path to get into Sky Harbor Airport in Phoenix. And there was a challenge as to whether or not they needed to move the way the planes are landing. And there was a poor lawyer from the FAA there. And the case was about whether it's arbitrary, capricious, or something. And Judge Silberman asked the lawyer, why do you do this by rulemaking rather than informal adjudication? And the FAA lawyer kind of hemmed and hawed, and because that wasn't what the case was about, he just kind of answered. And Judge Silberman, that's not good enough. Like, he stopped, he said, no, I need an answer. Why do you do this by rulemaking and not informal adjudication? And the lawyer obviously does not have a great answer for this. And then Judge Silberman, not content, he says, okay, do you know the difference between rulemaking and informal adjudication? And the FAA lawyer, this is the DC Circuit, you have to know the difference if you're going to walk in there, says yes. Judge Silberman says, okay, tell us, what is the difference between rulemaking and informal adjudication? And this poor lawyer was struggling, and it was awful, and it was awkward. Everyone in the room were like, oh no, like I didn't want to argue a case in my life if that could come up. And anyway, the case gets decided. Judge Silberman writes a concurrence, and he says, again, I'm paraphrasing, for the life of me, I don't understand why they do this by rulemaking rather than informal adjudication. And that is one of the strengths of Judge Silberman is the APA is a mess. There's a whole bunch of things that kind of loosely fit together, and Judge Silberman saw it all, and he brought cohesion and coherence to this thing. And sometimes in ways that I think are obviously the correct way to put it all together, and sometimes in ways that it could go different ways, but he was consistent and had a unified theme for how all this stuff was supposed to work together. And one of his themes, if you had to say, what is Judge Silberman on administrative law, was he did believe in restraint, and very much so. So one of the big cases in administrative law is Vermont Yankee. That is when the Supreme Court told the DC Circuit unanimously, cut it out. You're adding all of these things to administrative law that are nowhere found in the APA. So in the 1970s, the DC Circuit was doing all sorts of things, and the Supreme Court unanimously put a stop to it. And I had back when I had a research librarian, I had my research librarian go through and say, what are all the Judge Silberman cases where he cites Vermont Yankee? And the list was almost too long to read through. All the time, whenever he would approach APA questions, it was with Vermont Yankee on his mind. It came up all the time. And he would sometimes say, I'm bound by precedent, but I wonder if this is consistent with Vermont Yankee. And he would say that again and again and again. But then we get to the places where there's a little bit of a wiggle room in the APA, or people arguably wiggle room in the APA. Questions like, hey, how does Chevron fit in to the APA? The APA says the courts decide questions of law. People say, well, that means de novo review. Other people say, no, it means you apply any pre-existing standards, and Chevron predates the APA, and you have that fight. Judge Silberman was on the Chevron side of things, very much so. I remember when he came to Judge Brown's chambers, he went to meet the other clerks, and we could ask him anything. And I asked him, how does Chevron work when you have statutes that were enacted before Chevron? How can we assume that Congress in 1975 knew about Chevron, or at least legislate against that backdrop, when the court didn't decide the case until 1984? How does that make any sense? And he said, well, what are the premises of Chevron? And I said, well, that there's an implicit delegation. He's like, well, that's always been there. Well, I don't know if that's right or wrong, but he always thought it was there, and he defended it all the way through, even when some of the other folks on the Supreme Court started casting some shots at it. Judge Silberman was still there defending Chevron. I think he was concerned about some of the stuff that agencies were doing, and he had an answer for it in Chevron, but he was there. So part of his world was restraint. The DC Circuit isn't going to be in everybody's business. We're going to back up, and we're going to let you do your stuff. But there were limits to that on the other side. So one of the things that I think is most important from the DC Circuit, and the Supreme Court is just now starting to pick it up, was the fair notice doctrine, was the idea that we'll let agencies make policy. If they're going to make policy, they're going to make policy. But you're not going to make policy that nobody knew about and then get you after the fact. Retroactivity is a different thing than policy making. And one of the early cases on this, which is now getting cited all the time, was from Judge Silberman. And he said, essentially, regulated parties don't have to play Russian roulette when they're dealing with their regulators. Russian roulette was his quote. That is not a deferential idea. That is, no, this court is not going to let agencies do kind of fundamentally unfair things to people. And you also see that in, this is a very nerdy subject, in the line between legislative rules and interpretive rules and guidance documents. There's a number of cases where he wasn't going to let agencies say, no, we can get through the APA because we're just doing this informally. This is just guidance. He had tests about that, and he was pretty rigorous about it. And I think that those are all kind of important ways of putting all the pieces together. It's interesting, and I'm curious what the judge has to say about it, but we live in a time where the DC Circuit's monopoly on administrative law is rapidly decreasing. I read the DC Circuit cases, and the volume isn't the same, and the types of cases aren't the same. They still have their mandatory jurisdiction cases, but a lot of folks, if they can file their case not in the DC Circuit, don't file it in the DC Circuit. So the Fifth Circuit is a very interesting place for administrative law. Right now, the 11th Circuit, the Sixth Circuit, the Eighth Circuit, places that ordinarily in times past, they just didn't get the cases. And that means a lot of judges are looking at the APA for the first time in the way that the DC Circuit has been doing it forever. And I think we're seeing different folks reorganizing everything in slightly different ways, and we'll kind of see how that plays out. But I suspect that if we had more Judge Silbermans out there, it would be useful as all these new judges are looking at what he's been looking at his entire career as they try to put all the pieces together.
Great. Thanks, Aaron. Judge?
Well, it's a treat to be on the panel with Aaron and with Adam, and also a treat to be on a panel that was introduced by John Yoo. Aaron told me he has John Yoo's story that I was hoping he would share.
Still will.
Maybe later.
We have a long time for this.
Well, I'll share one that's connected to Judge Silberman because when Judge Silberman passed away, one of his current clerks came to work with me, and I noticed a book on his desk. I said, well, where'd you get that book? And he said that the Silberman family had been nice enough to say you could take a book or two from the bookshelf. And it was John Yoo's book, autographed by John Yoo, signed to the judge. And I have to say, there aren't many times I've been more proud of one of my clerks than when I saw that's the book that he chose. This is a little bit full circle for me to get to pay tribute to Judge Silberman. Oh, there's the clerk. There's Tiberius. Hi, Tiberius.
I just want to say, I'm glad it was a copy of John's own book and not like a copy of the Federalist that John signed to Judge Silberman.
So about 20 years ago, I was in my first job out of college, and I was asked to write a tribute about Larry Silberman. And they say there's no second chances in life, but today is maybe an exception to that for me because my boss at the time, Don Rumsfeld, knew Judge Silberman very well, and so he completely rewrote my draft, not for the first time and not for the last time. I'm hoping to do a little bit better today than I did then. though I suspect that if Larry could rewrite this draft, he might rewrite this as well. One of the things, of course, lots of things I think about when I think about Judge Silberman. One is his fearlessness, one is his grasp of the law, one is his humor, and one is that I wish I'd gotten to serve with him for longer than I got to. I also think about how he was willing to go his own way when he thought it was right, even if it meant sparring with his conservative colleagues, and there are plenty of examples of that. Aaron was talking about Chevron a second ago, which for the first panel today stole a little bit of our thunder. I think they talked about Chevron about half of their time. The ACA Obamacare case is another example of Judge Silberman kind of thinking independently, different than some conservative colleagues, some conservative judges. The size of the DC Circuit, I'm fortunate that he did not prevail in that issue, and Congress was not persuaded to reduce the number of judges on the circuit. I'm not necessarily agreeing with him about any of those issues, but actually I have to tell this. He was told by Justice Scalia after the Supreme Court decided the Obamacare case, well, if I had had the constraints of a lower court, Scalia said, I would have done what you did. And Judge Silberman said, if I had had the constraints of the Supreme Court, I still would not have done what you did. So the admin law example, though, that I want to talk about today, that hopefully will be somewhat revealing of the judge, is the topic of remand without vacatur. And I know that some of you are probably thinking to yourself, like, why did I pick such an exciting topic? And some of you are probably thinking, why did I pick a topic where Judge Silberman was wrong? But my point is not whether he was right or wrong. I'm not saying whether he was right or wrong. But I do think it tells us a little bit about him. So the kind of like 20-second, hopefully, setup of this is that the ACA says the court is supposed to set aside agency action that's arbitrary and capricious. And the normal remedy there is to vacate what the agency does. But on occasion, sometimes our court will not vacate even when the agency has acted unlawfully and will instead just remand it to the agency for correction while preserving the status quo, keeping the agency action intact. So back in 1994, Judge Silberman was on a panel with Judge Randolph, and they disagreed about whether remand without vacatur was allowed or not. And if you're keeping score, taking notes is Tchaikovsky versus SEC. And Judge Randolph said no, said this is not allowed under the APA. He used some awfully strong language. He said it's contrary to law. He said it rests on thin air. He said the APA flatly prohibits it. And so you can imagine that Judge Silberman's response to this was to just completely agree and wave the white flag of surrender. No, I'm just kidding. He said that Judge Randolph's argument finds support in neither logic nor precedent, that Judge Randolph's analysis was circular, and that it was quite wrong, quote, quite wrong. About a decade later in Sugarcane Growers versus Veneman, he went even farther. So in the Tchaikovsky case, Judge Silberman's point there was, we don't know why the agency did what it did. And since we don't know why they did it, we don't know whether their reasons were arbitrary or not. So we're not actually declaring it arbitrary. We're just remanding out of confusion so that they can clarify. And if they actually tell us their reasons and if those reasons are arbitrary, well, then maybe we'll vacate. But fast forward 10 years to Sugarcane Growers, and there it's a bit broader. He says, yes, the agency has acted in a way that's arbitrary and capricious. But we're going to follow, many precedents of the DC Circuit that say you can remand without vacating that situation. The traditional test for that, which Judge Silberman embraced, was, if vacatur is going to cause a lot of chaos, that's a factor that counsels against it. And if the agency can easily fix its mistake, then that's also a factor that counsels against vacatur. So, okay, why am I talking about this at all? Maybe you're wondering. The first I mentioned already. I think it shows a willingness to spar with some of his conservative colleagues and to think for himself, to say the least. The second is that this is a very live topic. We have to decide whether to vacate or instead remand without vacatur. Maybe certainly multiple times a year, sometimes multiple times a month. And we're still divided over it. And judges' conferences, I mean, we all know that our precedent says that it's allowed, but some judges are just a lot more hesitant to do it than other judges are. And it's also a live topic because it has some connection, I think, to the argument that the Solicitor General's office put forward in United States v. Texas, where the position of the Department of Justice today, I think, is that universal vacatur is not a remedy of the APA. I don't think that's what Judge Silberman was advocating for. I don't think that's what Judge Randolph was advocating for. I think it's kind of a third approach. And then I also finally am talking about this for a third reason, which is what else can it tell us about Judge Silberman? A couple of people have mentioned already his vision of the judiciary was a relatively modest vision, and you can see where remanding while keeping the agency action intact can be a sort of more judicially restrained approach than vacating each and every time, kind of no matter what the consequences of that would be. He went to law school, I think, during the Warren Court era, and heaven help him. If I had gone to law school then, I would not have. I would have wanted a more modest role for the courts as well. And we saw this. We see this again in Chevron and in the Obamacare examples. Maybe arguably a more modest approach than some of his conservative colleagues would advocate it for. And then the last thing I think it kind of reveals about him is maybe it reflects some of his experience in a regulatory agency, especially at the Department of Labor. And I wonder if there's a divide actually among the conservative judges who have not worked in a regulatory agency and the DC Circuit conservative judges who have. I haven't done a full study on the empirics of this, but I actually suspect that some of the kind of consistent proponents of remand without vacatur, Judge Ginsburg, Judge Williams, Judge Silberman had experience in regulatory agencies, and then some of the judges who have written somewhat extensively against it. So not just Judge Randolph, who I mentioned, but Judge Santello as well. Less experience or not any experience in regulatory agencies. And I don't know this for sure, but I get the impression that Judge Silberman did not look at his time at the Department of Labor and think, I worked in an agency, that was the worst thing. That was the worst thing ever. I think he was proud of his service. And I think that may have influenced his approach to remand without vacatur. Either way, I wish he were here to ask him.
Thanks, Judge. That's great. So again, we were expecting to have Professor Farrell here to jump in, and he's sorry he couldn't join us. So maybe I'll add just a few more thoughts of my own. In the first panel this morning, a few folks referred to Judge Silberman's talk to the ABA around 96, 97. Roman, you brought it up, and
89.
Was it 89? Okay. And Rachel did too. And that was one that was published in the George Washington Law Review, so you can read it. And it's a really interesting defense of Chevron. But as far as I know, the first time Judge Silberman spoke publicly on Chevron, he was actually very wary of it. He was very critical of it. At the first Federal Society Lawyers Convention, not the student convention at Yale, but the first lawyer convention, which was in '87, he was on a panel with Senator Hatch. There's a panel with Senator Hatch, Justice Scalia, Judge Easterbrook, Larry Tribe, and Judge Silberman. And Judge Silberman goes last, and when they get to him, he says, "How much time do I have?" And they said, "Well, there's 2 minutes left." You can imagine with that panel. And he said, "Well, I'll take 7." And then he spoke for about 12. But it's a really fascinating talk. I don't think it's ever been published, and I don't think the video's online, but the Federal Society has the audio out there. And Judge Silberman says, to think about Chevron, we need to start with Congress. Congress only acts collectively, and it only acts collectively when it enacts legislation. And that's very hard in our Constitution. It's hard for a reason, and we need to take that seriously. But he says through the compromise process that the Constitution forces, inevitably some things are going to be left unsettled, at least at the margins. And Judge Silberman says, and I hope I'm not misconstruing it, but as I took him to say, as he goes on, ultimately the job of a judge is to try to do justice to that compromise and not to sort of gerrymander the compromise and pick one side of the political debate, policy debate or the other. And he said, that's the job for agencies too. He said, the job, if the agency picked one side of the legislative bargain and ignored the other side, that would be illegitimate, he said. And so he said he worried about Chevron deference in that ultimately an agency would interpret a statute, and he did make clear, as Professor Barco said, that you're going to have vagueness in law for this reason. And so the courts and the agencies are going to have to grapple with vague language. And he said, if the agency reasonably interprets a statute, how can the courts give Chevron deference without risking being blind to one side of the bargain or the other? And so his theory of his wariness, initial wariness of Chevron, was that he didn't think it really fit with a sense of Congress's constitutional purpose to force compromise. What I find really interesting then is everybody's read Justice Scalia's article 2 years later in the Duke Law Journal about Chevron and Scalia's theory of Congress. And if Judge Silberman were here, I would ask him, do you think your comments at that conference were what spurred Scalia to write about Chevron and Congress? And then when Scalia writes that article and Silberman becomes a supporter of Chevron, in part because it's precedent, but I wonder how much Scalia's theory of Congress and Chevron convinced Silberman. So anyway, I think that's just an interesting footnote to history, and it's too bad that, as far as I know, that 87 talk was never published. I do think, though, that his focus on Chevron Step 2, where he says, he does, I think, say, I'm more of a Step 2 guy than Scalia is. I think there are more Step 2 cases. They are harder, and we do need to be deferential, but not just so open-minded that our brains fall out. We do need to be rigorous in Step 2. And when you read his early Chevron cases in the late 80s, he is focusing over and over again on whether, in one line he says, is the agency recognizing the legislation's reconciliation of the inherent tension of the statute, or the statute's reasonable accommodation of the conflicting policies. And he's thinking through Chevron Step 2 reasonableness analysis with an eye to Congress as a compromising body. And so, and I'll just say, he's over and over again wary of phony deference, either in Chevron or in Skidmore. He calls Skidmore non-deference deference. He talks about judges who will pretend to apply Chevron, but not really. He's over and over again thinking about the honesty and the honor, we'll get back to that, the honor of involved in being a judge. So this morning when Professor Prakash was talking about how should we think about Chevron in an era when the executive is different, and if you didn't hear the Chief Justice's comments last week at Jarkissi, where he really pressed on how should we think about administrative law precedents from another era with a very different administrative state, I think when we're thinking about Judge Silberman and Chevron, we ought to think, what would he think today with a very different Congress, where actually most legislation isn't the product of a compromise. It really is a red versus blue, very narrow majority in legislation. I'm kind of curious what he would make of Chevron, the more that Congress has changed, not just the executive. Really quick, I'll just say, in getting ready for today's panel, I was delighted to see how Judge Silberman really anticipated the major questions doctrine. When he dissented from the DC Circuit's decision not to rehear the case that became Whitman, American Trucking, he has a short dissent from the denial of rehearing en banc. And he does say that, he says, the panel decision's non-delegation analysis is, quote, rather ingenious, but it seems to me fundamentally unsound. He said because it really didn't, he think, faithfully read the benzene cases from the 80s. He thought that the panel decision, including his friend and I think law school classmate, Judge Williams, yeah, he thought that the panel got it wrong. But he said, this is interesting, he said, sad to say that the strong non-delegation doctrine hasn't been adopted by the Supreme Court. He doesn't dwell on it, but then he says, even with Chevron, a constitutionally dubious agency interpretation should be rejected. The constitutional avoidance canon trumps Chevron deference. And so just there in a line, he understands where Chevron fits, not just with the non-delegation doctrine, but with the principles of non-delegation that we're now seeing with the major questions doctrine. So he was way ahead of his time. I wanted to talk a little bit about his essay, but since we have copies sitting out there, you can read it. It's really an amazing essay. It's of a piece with his time at AEI, where he was hanging out not just with the lawyers, Bork and Scalia, but with Irving Kristol and Walter Burns. And he writes about the politics and the sociology of a litigious society driven by regulation. He says, the losers are capitalism and democracy. The winners are the lawyers. And the new class, that was Irving Kristol's term, of academics, media, and bureaucrats who all sort of thrive in that. And so Silberman was not a political philosopher of a sort, but in some ways he was, I think, the best kind of political philosopher. He really did understand the world as it was, and he really went about his job with that in mind. Maybe I'll leave it at that. Aaron, do you want to add to anything that the judge said? Judge, do you want to add to anything that Aaron said?
Sure. So I will say, so Justice Thomas came to BYU and he asked if he could teach a class, and he wanted to teach administrative law. And so I'm the administrative law professor, so I'm like, okay, I gotta get ready for Justice Thomas to come. And this is what he said about Chevron. And this is from his time at EEOC. He was like, when they decided Chevron, I told my staff, and again, I'm trying to remember exactly what he said, license to steal was the line that he said as he understood Chevron in the 1980s. So not everybody who was at an agency at the same time thought of it that way. And I also wonder, I've thought about that as well, if there's a difference between the folks that were at DOJ versus the folks that were in agencies. Because if you look at the current justices, I mean, you had City of Arlington, where the chief was very skeptical of Chevron and takes some shots at it, and he's joined by Justice Alito on that. And then you get Justice Gorsuch, who of course was at DOJ, and like on the 10th Circuit now on the Supreme Court, very kind of hostile. So I don't know how all that breaks down.
You should write this law review article.
He's a little busy right now.
After you win all the cases as Texas Solicitor General, if you go back to BYU, this would be great.
Honestly, who's going to read that article? We're going to run the room. I don't know. I think what you're saying. I mean, you're probably saying who reads any of them, but that's our lament, our chosen calling there. I think that it was right. One thing that made him deferential, but only to a point, was he did understand like how the sausage was made. Like he really got it. And that was why it was so fun to be around him, is he would just tell you stuff and you're like, oh, all right, I guess that's how Washington works. And it's more than anybody I've ever heard, like who just understood how Washington works. And you could imagine making somebody really cynical if you kind of see all that, but he wasn't cynical. He wasn't cynical. He was tough, and he held people to their lines, and he put them through their paces. But he saw it for what it was, but he still was ultimately a patriot, and that was a great thing about him. And there's not a lot of. I think that's hard to do. I think that just some of who he was, some of the time he came through, some of his experience. But I think that was some of his views on this is, I thought we heard earlier that he didn't like betting on international affairs. He didn't ever want to bet against the United States. He didn't bet against the United States in administrative law either. Like he had a deep confidence that like we're going to be okay. That let's hold people to the line. People are going to push the line on things. Agencies are going to push the line on things. So let's not let them do that. Let's not let them do that. But we have to have some trust in the institutions that things are going to work out. And if you trust people and you get the bad actors, but you trust, again, I'm not sure he's right about that, which is scary. But I think that was part of who he was. And when you talk to him, just the patriotism and just confidence in the United States was there.
I want to add one more thing, actually, about his sense of the world and how law is supposed to work. Because being on a panel with two former law professors, maybe a once and former law professor. I don't want to make it too law professor centric because Judge Silberman, of course, was in private practice repeatedly, both at firms and at the Croker Bank. And I read his approach to administrative law as deeply informed by that. And it was interesting on his passing, there's at least a couple of news stories that pointed out how many of his clerks went on to become GCs, right, went into private practice and so on. And of course, the judge was proud of his own time there. But he wasn't seeing administrative law, the rule of law, and so on, strictly from the perspective of the agency or the government. And that's the occupational hazard, especially in Washington or among administrative law professors, where they all either see themselves, they either have been in and out of government, or they can very easily identify with the government rather than the general counsel at a company. But Judge Silberman, very much not. And I think to the extent that he was trying to seek some stability in law, but not an artificial stability, the extent to which he understood that there's going to be an interplay between the agencies and the industry and the courts, I think that was informed by his time in private practice. And so I think there's always a risk when you talk about Judge Silberman, because his public service career was so legendary, that you almost give short shrift to his time in private practice, which I think actually really was one of the things at the heart of his sense of the rule of law. No offense to the law professors in the room.
I think that comes across in the article that the Lawyering and Capitalism article that you have out there that was referred to earlier, referred to here. He has this kind of riff on pro bono work, which, there's lots of wonderful pro bono work. But he says the idea that you are not kind of like serving the public as a lawyer unless you do it for free is quite a disservice to the profession. The profession is itself kind of pro bono work. Most people, Judge Silberman and his peers could have made a ton of money in business, which he had tons of respect for. Instead, they chose the law, which is likely to have a somewhat less kind of lucrative payout. And so he said, just money, lawyers who make money are serving the public. And I think part of what he saw there is, a business doesn't succeed unless there are gains from trade there, unless the business is providing a product or a service that is worth more to its customers and the customers are paying. And if the lawyers are helping the business there, they're part of a system that is not perfect, and we don't want to kind of Pollyanna-ish describe capitalism, but he thought it was a nice system, and he thought that the law should kind of complement it, not stifle it.
Yeah, he said, actually, I meant to mention this. He said there's two ways that the modern litigation and regulatory environment stifles capitalism. He says it makes it harder to make decisions because you have to think ahead of all the imponderable risks, and then it makes it harder to execute the decisions. And he's not talking about Congress and the legislative process, the executive process, although there's obvious analogies, especially with administration. But he's just talking about, for companies, trying to figure out what are we going to plan for tomorrow, what are we going to invest in, and then how are we actually going to implement what we think we want to do. And he saw, and I guess when he was at AEI, he was actually above counsel to doing Ballantyne, so maybe he was talking his book at the time. But he was cognizant of the dynamics of the administrative state and all that peripheral litigation on just the day-to-day actual business of America.
Can I say one more thing too?
Yeah, sure.
That some of the things that Aaron said made me think of. You talked in the end about his idealism and his patriotism in spite of living in Washington D.C. and not just living in it for so long, but kind of being so clear-eyed about it. I remember at his memorial service, Vice President Cheney speaking, and first of all, it's just quite amazing that the Ford administration, for as overlooked as it often is, and for as short as it was, produced so many incredible public servants. Judge Silberman's boss at the time, I think, was at Labor was George Shultz.
George Shultz, yeah.
Dick Cheney.
I feel like Rumsfeld edited this part of your remarks.
No. It's actually, so I remember. I'll give credit to the origin of this a little bit, because the Department of Justice Senator McConnell has told this story. He was a baby lawyer, and he's sort of just like sitting in the corner of the room in the Ford administration, and he looks around, and there's Larry Silberman, there's Robert Bork, there's Antonin Scalia. And it wasn't like some special like event. This was just like a Tuesday, at the Department of Justice in the Ford administration. My point is, I think that that group. I don't know that they were all kind of like born before World War II, but too young to fight in World War II. But that was an idealistic, like country first patriotic group, and I think Judge Silberman was an exemplar among them.
Well, that's a very natural segue to the honor paper. Do you want to talk about his speech he gave in 2009 called on Honor?
Sure. So I mean, this was a great speech where I think he talks about people. First of all, he talks about how honor used to be a concept that was often discussed. That's honorable. That's dishonorable. And now we don't as much. And then he goes through and he says, by the way, like people, it's not ought not be too surprising when people act dishonorably if it's not a value that we're just kind of like championing. But he goes then through how you, particularly as a public servant, can act dishonorably, he talks a lot about leaking when you're in an administration. Which I think Vice President Cheney would probably agree with his critique there. And he says, if you don't agree with the administration's policy, the solution is not to go try to undermine the administration with the media. It's to try to persuade the administration to change its policy. And if at the end of the day you don't persuade them and the policy is so egregious or illegal that you can't be a part of it, and if you're asked to do something illegal, you should never be a part of it, then the only option there is to resign. And he goes through then exemplars of people who acted honorably by resigning. Yeah. And in I think it was the first sitting I had with Judge Silberman, we had a case where fellow at the Department of Defense was suing the Department of Defense over a Department of Defense policy. And you can imagine, like Judge Silberman did not think this was how things were supposed to work. And I got to write the opinion, and I was able to put in there as a citation to, if you think a policy is so bad or so illegal, you're supposed to resign. A citation to what Judge Silberman did when he was pressured by some Nixon officials to go easy on a Nixon ally, and offered his letter of resignation. Didn't run to the New York Times and leak the story and try to he just offered his letter of resignation.
Yeah. So this is a great talk, and this one actually was published in the Harvard Journal of Law and Public Policy, so you can and you should read it if you haven't already. I'm sure in this room tons of people have already read it. But he talks about civil servants, and he says civil servants, they shouldn't leak to the press, they shouldn't go leak to the other party in Congress. But he says, of course, given the whistleblower laws and the inspectors general, of course there are appropriate times for somebody in the civil service to talk sort of outside of the agency. But he distinguishes that from just running to the political party, the opposition party, and bringing them the goods. And that's such an interesting way to frame it, because what he doesn't say it explicitly, but what it points out is at the end of the day, there's a right way. You can do the same thing for the right reasons or the wrong reasons. And the reasons matter, right? That whether you're blowing, it might be blowing the whistle, it might not. And the difference might really lie in your own mind and conscience about what you're trying to do, what you think is happening. And that matters. And when I read that, getting ready for today, it reminded me of all the times in administrative law writings, like that George Washington Law Review article, the ABA talk, where he said, virtually any phrase can be rendered ambiguous if one tries hard enough. A lot of his theory of Chevron deference, it wasn't just about applying rules, but it was first begins with the person, whether it's the judge, whether it's the administrator. Like what's in their gut matters. What's in their conscience matters. And of course, then you can't just count on that, and so you try to build legal structures around it. And I think a lot of his approach to administrative law, especially in Chevron Step 2 and other things, was trying to police these things. But one of the reasons why I love that talk on honor so much is that he did exemplify it himself. And in these different places that might seem very, very different, he's really bringing you back to, in Washington, how much your principles matter. I like the line at the beginning where he said, nobody talks about honor. He says, we used to call politicians, every once in a while you'd say, that politician is dishonorable. But we don't even bother saying that anymore because we don't really think in those terms. But the judge definitely did. Aaron, any closing thoughts on Silberman, or do you want to tell your John Yoo story, by the way?
Sure, I'll tell the John Yoo story, and then I'll do some closing thoughts on Silberman. Why not? So this story has nothing to do with Judge Silberman. I don't even like it. I don't know. But in 2007, I was invited by a campaign to go to CPAC. And I had never been to CPAC before. And look, I'm about as conservative as a person can get in this world. But I don't have any buttons or anything. So I'm not maybe the typical audience of CPAC. And I'm there, and I'm looking around, and there's people in dolphin costumes, and there's all sorts of things going on. And I see John Yoo, and he's there, and he's selling books, and it's obvious that nobody knows who he is either. So I go up to him, because I at least knew who he was, and I walked there, and I'm like, but I'm going to get a chance to talk to John Yoo again. So I'm over there talking to him, and when all these people are going by, and it's clear that nobody knew who he was, and then somebody came up to him and said, kind of leans in and says, do you know where Newt Gingrich is? Because Newt Gingrich was going to be speaking in one of the rooms or something. And he looks at her completely straight-faced, and says, I am Newt Gingrich. and she doesn't know what to do with this. She was looking at him, because he doesn't break character at all. There's no smile or anything. And that's what she says. She sees that he has books or something, and she says, oh, do you sell your book on the Conservative Action Network or something I've not heard of before that evidently sells books? And he says, I have no idea. She's like, who is this? She did not understand what was going on. So then she says, I've solved this. So she says to him, are you ever on the radio? And he says, I'm on NPR all the time. And she left. She had no idea what had just happened there. That doesn't have anything to do with anything with Judge Silberman. But I don't know if he would have enjoyed that story. But that was my John Yoo story. To kind of close it up on administrative law, I think that we're in a time of transition right now with administrative law. I think that a lot of the assumptions that Judge Silberman had about how things are, I'm not sure that they all hold anymore. And I think a lot of places, so for instance, regardless of the party, presidents know that they get elected by doing big things. They know that Congress isn't going to enact those big things. So you go rummaging around statutes to see what you have that you can maybe arguably push and try to see if you can get that big thing done. Sometimes you're within the law, sometimes you're not. But that's a completely different way of doing administrative law than I think that Judge Silberman and those folks who went through that period when they were doing those sorts of things. And I think that if we live in that world and the APA has holes and a lot of things the Supreme Court has not decided, and you have to put a bunch of complicated things together, I'm not surprised that different judges in different courts are looking at this and saying, wait a minute, what is going on here? And I think that's a call for the Supreme Court. The Supreme Court, I think, needs to take more of these cases on foundational stuff, not individual cases, foundational stuff. How are these things supposed to work? So we have some uniformity across the courts. But I also think that if we're really going to have the APA and administrative law work, Congress needs to work. And I'm not saying on everything that's not going to happen, but on certain things, Congress needs to get together and say there's some basic building blocks of administrative law that maybe worked in 1946 that do not match what we're doing now. Behind the veil of ignorance, we don't know what's going to happen in 4 or 8 years. Somebody needs to figure out how this is going to work, and let's get this done sooner rather than later in a way that we can have an actual structure, because we live in very complicated times, and lots of cases are being brought by folks who do not have Judge Silberman's experience and knowledge of the APA, and it's no way to run a railroad. So I despair a little bit about where things are, not because I think judges are doing a bad job. I think they're doing remarkably well considering how hard the situation is. But this is a really complicated body of law, and we don't have the clarity that we need from the court and from Congress. So I worry about that.
Well, actually, talking about administrative law at a time of change brings me to something I did want to ask the judge about, but I'll first start with a story. I did not clerk in the Silberman chambers. We didn't talk about the Ford administration. I clerked in the Centel chambers. We talked about Willie Nelson albums and actually tried to get some Johnny Cash lyrics and some footnotes from time to time. But one thing that Judge Centel really impressed upon me, this is before he was the chief judge, was how hard it was in the 80s when administrative law was changing so quickly to hold the court together. And there was a real risk that the DC Circuit was basically becoming Beirut on the Potomac, and the judges it was a very, very hostile place to be, and that Judge Edwards and after him, Chief Judge Ginsburg, really, really worked hard to build collegiality in the court in the way they worked together. And I recently heard Judge Edwards tell the story about, very, very recently, about when he was the chief judge in the early 80s, and things were getting really bad, that with conservative judges trying to en banc everything, and now we call them progressive justices going nuclear on things too, Judge Edwards was very worried, and Judge Silberman became his greatest ally, sort of newly arrived on the DC Circuit. Judge Silberman, as Edwards tells the story, really, really worked on Judge Edwards' behalf to build collegiality and actually make the court a functional court again. And when I heard Judge Edwards tell the story, I mean, the affection that you could see in Judge Edwards' eyes remembering this, about how important Judge Silberman was. And you wouldn't think of necessarily from the outside of Judge Silberman as like the teddy bear that brings everybody together. But in his own way, really working in partnership with Chief Judge Edwards to make the court. And that's a very long way of saying, needless to say, a lot of administrative law is sort of being contested right now, and I'm a big fan of a lot of that. But I'm sure it does put courts across the country under a lot of strain. And I'm not asking you to talk out of school, but I'm just asking, since you are in a similar situation as a judge on the DC Circuit at a time of change, what's it like being on a judicial body, working collectively and collegially, where you're really but you're debating principle, but you have to do it together. And I'm wondering if that's given you a new window into Judge Silberman's career.
Well, I think that I try to imagine my job as a team sport. I was a district judge for about 5 minutes, and that was like a solo sport. That was like singles tennis. Okay? But I try to think when I'm on a panel, to approach the job with respect for my colleagues and with humility. Judge Silberman was not just a part of kind of revolutionizing the DC Circuit from a not collegial place to a model of collegiality. He kind of he didn't just talk the talk, he walked the walk. And so Judge Edwards has written that the single most important thing that was done to turn the court from Beirut to collegiality was nothing that Judge Edwards did. It was one vote that Judge Silberman made. The court had agreed to go en banc along fairly political lines with a conservative majority to overturn a left of center, all these labels are bad labels, but a panel of Democratic appointees over a Republican appointee's dissent. And then it was something of an administrative law case, and also something of a free exercise case. And Judge Silberman had voted to go en banc, and then Judge Silberman changed his vote and said, we're going en banc too much. It shows disrespect for our colleagues. It shows disrespect for panel decisions to think that just every time we disagree with a panel decision, we should just willy-nilly go en banc. Now, I'm not necessarily endorsing any particular standard for en banc. I'm talking about his reasons for why he did it. And the reasons were quite noble. And the effect was, I think, quite profound. In the 80s, the DC Circuit went en banc, I think, something like 63 times. And in the 80s, in the 90s, rather, they went en banc something like 33 times. So it's quite a drop. And I haven't done the statistics, but I doubt that in the past 10 years, we've gone en banc 33 times. Even the 90s statistics. We voted to go en banc twice my first year on the court, and this is my 4th year. We haven't voted to go en banc since that year, not once. And so I was talking to my clerks at the beginning of this year about, what do you think an en banc standard should be, and when should we vote, when should we write a dissental, and they said, well, why are you kind of not doing more? Why is this even a close question for you? I think I did ultimately vote to go en banc in that case. But why is this even a close question for you? And I said, I want to not. Maybe we have the right standard, maybe we don't. But I think we ought not just throw it out the window like day one of my job when it's an inheritance that was like a hard-won inheritance by people like Judge Silberman. Like, they built it, and it's probably not a good idea to just like blow it up 5 minutes after I start the job.
Right. Thanks, Judge. We do have time for questions. Usually at an AEI event, the moderator has to say, please be sure to phrase your question in the form of an actual question. But at an event like this, I'd actually kind of welcome people to phrase their question in the form of a statement, given all the folks here who knew Judge Silberman so much better than actually really any of the three of us, including the judge sometimes. So raise your hand, the microphone will find you. Anybody can jump in. I mean, who doesn't want 15 more minutes of administrative law talk? Sally Katzen. It's right behind you, Sally.
I've had a couple of thoughts. And the preface to this is Adam has heard me say at a number of Federalist Society meetings, I hate to be the skunk at the picnic. But I disagree with some of the more conservative leanings of some of the people who are speaking and how they characterize things. And I would ask a couple of things. One, Adam, you spoke about the Jarsky argument.
Yeah.
And this is inside baseball, and I apologize to everybody, but this is the case that is being raised now that is trying to upset some of the law the administrative law as it has been settled. And you said that Chief Justice Roberts said, well, the administrative state isn't what it was 50 years ago. I mean, it's much more powerful and invasive and intrusive. And I question the factual predicate of the growth of the administrative state in the last 50 years. We saw an enormous growth in the 70s with EPA and in the 80s with a number of other agencies created. But the amount of administrative law that has been authorized by Congress in the 90s, the aughts, and the teens is not noteworthy, I would argue. But if you're going to make statements about the growth of the administrative state, for God's sake, look at Capitol Hill. Look at the demise of Congress. Look at the inability of Congress to tie its shoes. They can barely get the budget out, and it only comes out in an omnibus form rather than in the 12 bills that should all be done by September 30th. You want Congress to make more finite decisions? You want Congress to address some of the things that are willy-nilly called major questions, when in fact they thought they had made some of those decisions. But they certainly are not capable of making those now. And if we're going to worry about the growth of the administrative state, I would hope we would think about the demise of the legislative state and its inability to respond. And those who say, well, just let Congress be more precise, I think are somewhat unrealistic. I appreciate very much your comments about the patriotism of Judge Silberman, and I grant you that he was truly a patriot, and I knew him as a friend as well as a colleague. And I just wish that we were willing to call some of the Democrats who question some of these principles patriots as well, because it seems to be a one-sided compliment that sometimes is disconcerting. And let's get back to administrative law. The one question I have, or what I would say the one stain on Judge Silberman's legacy, is there's been talk about restraint. He was going to be restrained, and he saw that as an important thing. How then do you understand paralyzed veterans?
Oh, good.
It strikes me that he there took a giant step on the issue of guidance, and if you're going to change if an agency were going to change its mind, it could only do so by going through notice and comment. And the Supreme Court, I think it was 9-0 in Perez, said, no, I don't think so. And I remember calling Larry afterwards and said, I don't think you won this one, my friend, which he didn't. But that was the one stain on what I think had been a fairly consistent step by step. And for that reason, I'll go back to question what all of you have said about, and mostly Adam, that Chevron, that he would see Chevron differently, because it's such...
I don't know about that. I don't mean to go that far. I'm just saying I would love to ask him what he would think of Chevron in a different era.
Last time I did, he was still enamored of it.
Yeah.
It's tough to say, but I think he had a principled approach, as Rachel had said in the very first panel, that if it is ambiguous, then you have two choices. The agency with the expertise or a judge. And of the two, he strongly preferred the former. I've talked too long, but you did ask for comments as well as...
Let me say everything about the Chevron thing and then paralyzed veterans. On Chevron, for what it's worth, I with all due respect to the other folks on the panel, the first panel, I thought my reading of Judge Silberman on Chevron is exactly Rachel's, Professor Barco's reading of Silberman on Chevron. I think the way she described it is exactly right of his sense of Chevron, what he was trying to do. And most importantly, his conclusion that you cannot avoid ambiguity in a lot of law, that Congress ought to try to narrow the law as much as possible, but it's almost impossible to wring at least some uncertainty, wring out all the uncertainty out of law, and that administrative law has to grapple with that. And I think maybe I'm overreading him. I think one of the reasons why he was comfortable with that fact is because he worked in government and in private practice, and he wasn't a theoretician, and he understood that the world's going to be a messy place. And you're trying to reduce that uncertainty for a lot of reasons, but you'll never do away with it. So actually, to be clear, I don't think I'd be surprised if he would have changed his mind on Chevron today, 10 years from now, but I'd be curious to hear him think through Chevron now, in light of Congress being different. I will say, though, Sally, on the point of Congress, at the end of that essay on lawyers and capitalism, he says one of the dangers of the courts and litigators and regulators taking on so much of the gravity in our policymaking process is that the more that the Supreme Court volunteers itself to do, the less that Congress and presidents will do. And it reminded me of today, these days presidents always say, if Congress won't act, I will. But that actually means Congress won't act because the president will. And I think, in a way, what we're seeing now with the totally desiccated Congress is the bitter fruits of the things that Silberman and others saw 40 years ago about other parts of government pulling so much of the policymaking energy towards themselves. And so you can look at Congress now and say, yeah, Congress is a total joke. But actually, I think that proves Silberman righter rather than wronger in his assessment of how this should work. The paralyzed veterans doctrine, I'll turn it over to Aaron. For the uninitiated, that's the doctrine that says when an agency makes a regulation and it's ambiguous, and the agency gives it a conclusive, authoritative, definitive interpretation, then that becomes the meaning of the regulation, and you can't change the interpretation without actually amending the regulation. And Sally is right that the court overturned it, that the decision paralyzed veterans 9-0. I actually think, and I wrote an amicus brief in support of the doctrine at the time when I was still in practice working with Boyden, but I thought Judge Silberman had it right, in part because it's premised upon an idea that maybe the law's meaning isn't clear at the beginning, maybe the law becomes a little bit more settled over time, practically speaking, and that has to be given some due weight. That's not to say textualism isn't right, it's that textualism is basically right, but sometimes at the margins it gets very, very difficult and you have to be practical. But Aaron, what's your sense of paralyzed veterans?
So I got to say that when I started looking into this, that was the case I was thinking about. And that's why I had my assistant look through the Vermont Yankee cases, because I did not expect to see what I saw, given that I started with paralyzed veterans, which everybody said, well, that's inconsistent with Vermont Yankee. And so I went back, I read Paralyzed Veterans again. I haven't read it for a long time, I just know it. And that's a really complicated case. And it wasn't an ideological panel by any means. And I wonder if, and his analysis isn't even that, Adam. Like his analysis was his take of the text of the APA.
Yeah.
So Homer nods. I don't know if he just misread the APA on that one. You would know better. You probably asked him. I've never known. But that was one where I was a little bit surprised by it. But on the other hand, if I had to link it with his other cases, he did try to give content to the line between interpretive rules and substantive rules. And I don't know if I think people can push on some of those cases as well, because when I teach administrative law, I say this guy knows a billion times more than me, and Steve Williams as well. And I don't think their tests are all that great at coming up with the line between substantive rules and interpretive rules. And I don't know if that's part of the same struggle where the DC Circuit just has to try to figure out what to do with that. That's why I go back to examples of things that Congress should fix with the APA, is how exactly is that supposed to work? Because that's one of the most important lines in the entire statute. And it's a complete mess, and it's been a mess for 70 years. Everybody knows it's a mess, and yet we still are stuck, going through it. So maybe you can get that fixed for us, because I don't know how to fix that, but Congress really ought to do something.
Judge?
There were plenty of things you said that I agree with. I'll maybe briefly touch on three things that I'm not sure I'm fully on board with. The first is the Chief's comment at oral argument in Jarkissi. I think one of the reasons that he was saying this SEC is not your grandfather's SEC is that they're doing something that wasn't statutorily allowed until after the financial crisis in 2008. So I think there's a larger question of whether there's more regulation today than there was 50 years ago. I think yes, but I think in this specific context, I think he was on pretty solid ground. To your patriotism point, there are 15 judges in our court. I serve with 14, patriots, and I try to be a 15th. So it's not a Republican Democratic thing in my mind, and I really don't think that Adam or Aaron were suggesting otherwise.
No, this is an event for Judge Silberman.
And then on the restraint issue, he writes about kind of what judicial restraint is and what it's not. And I forget if it was in the Lawyering and Capitalism article or if it was in the retrospective 20 years later. But he distinguishes judicial restraint from political restraint. And, you know, calling a statute constitutional when it's not, he says that's not judicial restraint. That's just like abdication of the job, and not overturning a precedent when traditional stare decisis factors counsel in favor of overturning it. I think that's not judicial activism. That's the job. I think it's the politician's task to know where the public is, and sometimes to maybe stay a step ahead of them. And then when they get there, you know, you pull them a little farther, and they get there. That's political. You know, Lincoln was a master of this. That's political restraint. But that's not. I think incrementalism is not necessarily synonymous with judicial restraint. And I think. I think I'll stand by the Judge Silberman exercised judicial restraint at least you know, that's a general rule.
Yeah. And I'll just one last note on the ad law points. For all the talk about major questions doctrine right now, we often debate it in terms of the non-delegation doctrine. But a lot of the time, a number of the justices are talking about it in terms of reliance interests. Right? You have a big statute with a lot of discretion. Well, the longer that the agency has not sort of discovered this new special unprecedented power in a statute, the more the court seems inclined to let people rely on the agency not having discovered this power for the first 70 years of the statute. It's a lot about reliance interests. And I think that, and you see that in other parts of law, arbitrary and capricious, Judge Silberman on unfair surprise. And honestly, I think when I went back and reread Paralyzed Veterans, it feels thematically very similar, right? That once the agency has put this definitive interpretation on the regulation, yeah, there's always going to be room for a change. And Silberman, like Scalia, knew that one of the features of Chevron was its capacity for the right kind of policymaking change. But so change is a good thing, but you can have too much of a good thing. And I think that Silberman's approach in Paralyzed Veterans was very much of a piece with his sense of Chevron, his anticipation of the major questions doctrine, and other things. We'll close on just one last story. I know we're a minute long. I was very lucky to clerk for Judge Santel, but unlucky to clerk the year that Judge Silberman was on the WMD Commission. And one of my lasting memories of that year was there was an oral argument with Judge Santel and Edwards, and I can't remember the third judge, but it was the classic Santel-Edwards show where they would keep alley-ooping, just dunking on the lawyers. You know, Edwards would throw it up and Santel would dunk on a lawyer, and then Santel would throw it up and Edwards would dunk on a lawyer. And it was just one of those days you were so lucky to be a clerk at the DC Circuit and lucky not to be one of the lawyers at the DC Circuit. But after the arguments, I went back to my office, which was in the hallway. And from that long hallway in the DC Circuit, about a half hour later, I just hear laughter. Just laughter. And it gets closer and closer, and I realize it's Santel and Edwards, and they're laughing the whole way down the hall at how much fun they had that day. And they finally get close enough, and I hear, I think Judge Edwards say, only thing would have made it better would be if Larry were here. And so, of course, that's how we all feel today, how much better today would be if he were here. But we're very, very lucky to be joined by a lot of friends today, and among them, please join me in thanking Judge Walker and Solicitor General Nielsen. All right, so we'll take another break, and the panel on Silberman and national security will be at 3 o'clock.
Actually, my faith now is
If we could take your seats, please. Thank you. We're about to get started.
Well, I was a follow-away Catholic. I lost my wife after 51 years. And a gal walked into my life and burned religious.
Okay, please take your seats, and we'll get started. So it gives me a great pleasure to moderate this third panel, and I'm really going to make time for a lot of questions and comments from the audience, given the moment we're living in. I think this is one of those times where AEI and a panel like this could really help us figure out what to do in this time that seems like a turning point in our foreign policy and world history. As I said in the morning, I always thought Judge Silberman's first love was foreign policy and national security, and that he practiced law and became a judge just to pay the bills. He was an ambassador to Yugoslavia. He always, this is an interesting story, he once told me he thought that he was sent to Yugoslavia by Henry Kissinger so that Kissinger could get a rival out of the way. Sounds like Kissinger, right? Because he knew how close Kissinger was to Nixon and Ford, and thought that they might pick Judge Silberman to hold a very high foreign policy position. He eventually I think at least twice turned down cabinet level appointments in the national security foreign policy area, including becoming the first national intelligence director. But I think he performed a wonderful service for the country in this area when he headed the Rob Silberman WMD Commission. So I asked the three panelists not to talk so much about Judge Silberman's careers and thought, but I think to talk about what Judge Silberman wanted to talk about, and which he was talking about a lot at the end of his life, which is what we should do in terms of a conservative foreign policy at a time when we are under severe challenge around the world from China, Russia, and Iran, and at a time when the public is not so strongly in favor, it seems to me, of a really engaged international foreign policy. So I think I can't think of a better time, a better panel to discuss this. Let me introduce General Jack Keane. General Keane grew up in New York City. He went to Fordham, and then he became a parachute ranger in Vietnam. After service in Vietnam, he rose to become a 4-star general and to become vice chair and acting chair of the Department of the Army. I think actually he has, I think I heard Tricia say to him right before the panel started, Judge Silberman loved everything he's ever heard him say on TV, right? Because I've never heard Judge Silberman say that about anyone, including myself. Judge Silberman, General Keane, has gone on to, I think, an even more influential role in our national life as an advisor to presidents, secretaries of defense, congressional leaders. About what to do. Most famously, he came to AEI in 2007 out of office and helped develop the strategy that led to the Iraqi surge. I struggle to think what would have happened in Iraq had he not performed that great service. To his right is Ambassador Chris Landau, for former Thomas and Silberman clerks here. He's a familiar face. Chris just recently served as ambassador to Mexico, comes from a foreign service family. His father was an ambassador in South America. Before he finally graduated to the higher calling of foreign policy, he was an appellate lawyer in Washington, D.C., like many Silberman clerks and many Thomas clerks. He went to Harvard College, Harvard Law School, clerked for Thomas on the D.C. Circuit, and then Scalia and Thomas on the Supreme Court. He didn't get it right the first time with Scalia, so they had to have him come back and clerk for Thomas on the Supreme Court the second time. And he was Justice Thomas's very first clerk on the Supreme Court. And then he went on to practice here in San Francisco. I wish. I was in Washington for a variety of the top firms in the country. And then we're very lucky to have with us Jakob Grigiel, right, who is a professor at Catholic University, has written, I think, some wonderful books. The Return of the Barbarians, The most recent book I thought was a really fabulous book that talks about the era we are in. Jakob went to Georgetown for his undergraduate degree and then Princeton for his PhD. He was a professor at the Johns Hopkins SAIS School, and then he worked at policy planning, which those of you who are State Department nerds, like I see Edwin there, he's definitely one of them, which is the internal think tank of the State Department, where, for example, George Kennan, people like Robert Bowie, Walt Rostow, you think about the great minds who have shaped our foreign policy, all come from, it's like the Office of Legal Counsel for the Department of State. So Jakob is with us as well. So we're going to have about up to 10 minutes of comments and lecture perhaps from each of the panelists, and then I'll ask them to comment on each other, and then we'll go right to questions from the audience. So General, why don't you start?
Sure, thanks, John. Appreciate the introduction. And also, delighted to be here in a small way honoring Judge Silberman and his life and contribution to this country. And delighted to see members of the family here as well. Also, it's great to be back at AEI. I have great respect for this institution and genuine affection for it, frankly. Also honored to be here with my colleagues and panelists, and also with John, who I've had a lot of respect for all these years. You know, we're supposed to talk about the war in the Middle East and certainly the war in Ukraine, and we'll get to it. But in my mind, I'd like to put it in a strategic context for you before we get into some of those details. I very strongly believe that the global security challenges the United States are facing today are on a scale we haven't seen since World War II. The world's more complicated, more comprehensive. We have major adversaries in China, Russia, Iran, and North Korea. They're all operating in their own national interest, but you see every single day they cooperate with each other in a common interest. And that common interest is the United States. To replace the United States in international order as we know it. And when they look at the United States, they collectively see, in my mind, a country that is more vulnerable than it has been in the past, that's somewhat in decline. And I think we have some evidence of that ourselves, if we're honest about it. And they also are much more aggressive as a result of that. And the facts speak for themselves. 2 national security strategies, one by the Trump administration and one by Biden, identified 3 geographical areas of the world where we have vital national interest. One is Europe, that's been obvious all of our adult life, the Middle East, and also the Indo-Pacific region. Well, where are we? We have war in 2 of them. And in the third one, the leader for the last 12 years, now the last 3 years, has been more aggressive than he's ever been. And he's threatening war. And he's got a military that has the capacity to execute it. And his aggressiveness against the United States in the last 2+ years is rather significant, as well as our allies in the region. I think we're in very dangerous times. This administration that I have provided advice to, I've been in and out of the White House 4 times just on China alone. I've been critical of them publicly. I'm surprised they want to hear from me. But I've been there doing that with them. I'm on the Secretary of Defense's policy board and met with him this week and our policy board members, and we were challenging certain assumptions that they've made about the wars we're fighting. And I think they need to be challenged, and I think the strategy needs to be challenged. I'm also on a congressional commission that's looking at the national defense strategy. We're nonpartisan, and I was on the 2018 one, and we found it wanting. The strategy made sense, the implementation was far from what it should be. And we were alarmed by how ill-prepared we were. The situation since that time is worse. And they're not telling you about it. This administration is not telling you where we really are and the dangers we are posing. And it's about time you get treated as the adults you are. We can deal with challenge and difficulty in our lives. There's a reason why they're not telling you, because the next question is, what are you going to do about it? And what are you going to do about it is something they don't want to face, because it results in a fundamental change in their strategy and also their policy objectives. Our adversaries also know the United States military is not what it used to be. Despite the fact we have senior leaders like myself saying that we're the best military in the world, et cetera, et cetera, et cetera. But 20 years of 9/11 wars have eroded our capabilities, and apathy and complacency during those years in terms of building for the future has eroded those capabilities. We are not where we should be. And our adversaries who pay a lot of attention to it know where we are. We have lost our capability, in my judgment, to deter our adversaries. If you don't believe me, look at the facts. We didn't deter Putin for his invasion in the Ukraine. We have not been able to deter Iran in this administration from January of 21 to the present. They're flush with money. They're more aggressive than they've ever been. And their objectives to to dominate and control the Middle East and drive the United States military out of the region using proxies to do that has been quite successful in my view. And it's no accident that Hamas, one of their proxies, sees vulnerability in Israel, sees vulnerability in the United States, and we're at war in the Middle East. Those are the realities that we're facing. The war in Gaza, just real quick the objectives that the national authority has assigned to its military is to dismantle Hamas as a military and terrorist organization, and also change the political entity that it represents in governing the country. Those are the objectives. Can we get there? It's going to be very challenging. Changing out Hamas as a political entity is probably doable. What replaces it is another matter. My Israeli sources as of this morning, which are solid, they don't have a very actionable plan to have a replacement for Hamas. It's complicated, to say the least. The military operation that's being conducted in front of you is unique in the sense that urban warfare normally is conducted with the vast majority of the people not being present who live there. The sound of the guns get close, what do people do? They flee. In Gaza, people can't leave Gaza. The Egyptians refused to set up refugee camps sponsored by the UN, funded by the Arabs. And as we all know, Hamas holds the people captive as well. So we're fighting a war, building by building, with the presence of people in the neighborhood. You didn't see that in Mariupol in Ukraine. You didn't see that in Bakhmut in Ukraine. People were gone. You didn't see that in Mosul in Iraq. People were gone. You didn't see it in Fallujah in Iraq. And you didn't see it in World War II. Not that we didn't conduct bombing campaigns with people in present, but I'm talking about urban warfare with ground troops and air power. That is very, very unique and demanding. The pressure this administration is putting on the national leadership in Israel, I think, is wrong. I think we should let Israel accomplish its military and political objective. But it's a fact, as of this morning, they're pressuring them to end this campaign in 2 to 3 weeks. That's the reality of it. The United States is Israel's indispensable ally. If this campaign shuts down in 2 or 3 weeks, they will not accomplish their military objective. Why? Hamas is a military organization more than a terrorist organization. It's organized into military units. They have 5 brigades, 24 to 25 battalions. Most of 4 brigades are intact. Many of the middle leaderships in the 5 brigades have been killed, but not all of them. And their top leaders have not been killed. Some have, but the top ones have not. So much of the war is in front of the idea, much less call a halt to it and a ceasefire in a couple of weeks. that would not accomplish the objective they want. And the reason is obvious. The military organization will be left intact. They'll switch to going to high-value targets and try to kill leaders, but pull away from dismantling the effectiveness of that organization. It makes the Israeli people vulnerable to an attack again. I'm going to stop and not talk Ukraine because I've already talked too much. Now, you catch up to me in question and answers. I'm current. I chair a think tank in town here that tracks the war, both of these wars on a daily basis, so a bit of every single day, 7 days a week. I'm involved in both of them. And I'll be more than happy to take detailed questions on anything you want to talk about.
Thank you, General. Ambassador Landau.
Thank you, John. First, let me just say how honored I am to be here and frankly, how much I miss Judge Silberman in these days. I'm sure we all feel that way, but he was someone that I always loved talking to just to get ideas. You could never have a dull conversation with Judge Silberman. And you know, he was opinionated. He let you know what he thought, but he was also, I think, interested in having people push back. He wasn't looking for yes men or women, and liked to challenge people. And I think liked nothing better than having people say things that he found kind of unexpected. So, you know, and when the world is in kind of turbulent times, he's somebody I would have loved to talk to, and somebody who was, to me, more of a mentor than anybody outside my immediate family. And Mrs. Silberman, it's nice to see you and the kids here. Annie, I see you out there. And your father was like a second father to me, and I'm very grateful to him. You know, I think on foreign policy, in some sense, Judge Silberman had it easy in the sense that I think foreign policy for those growing up in the 50s, 60s, 70s was pretty clear cut, at least from this vantage point, that we had clear interests in the world, that our foreign policy objectives were, again, there's a pretty broad consensus that the Soviet Union and communism more broadly was a great national challenge to the United States. You know, in Europe, obviously, that's why we created NATO in the wake of the Second World War. But really, it was a global challenge. And so, you know, during that period, the American foreign policy establishment grew explosively. You know, I think we kind of forget now, you know, before World War II, we did not have a big international footprint. This is not the norm through our history. You know, since World War II, obviously we've had, you know, bases in Germany, Japan. We have this big worldwide network, and American foreign policy kind of became, you know, a threat to freedom anywhere is a threat to freedom everywhere. So, you know, pretty much every country became critical. You know, it's critical what happens in Malawi. It's critical what happens in Paraguay. It's critical what happens in East Timor. And, you know, the United States had the economic might to carry this off. But again, there was a sense of mission. We understood at least what we were doing in the world. If you were the ambassador to Malawi, you know, you knew that your main goal was to prevent, you know, left-wing anti-American forces from trying to get a foothold there. You know, I think that sense of mission obviously collapsed with the end of the Cold War. I mean, we won. It's the good news, right? I mean, the Soviet Union collapsed. That was our big global enemy. But yet, from my point of view, we never had a discussion in this country. Okay, what is the role? What are the vital interests of the United States? You know, after the end of the Cold War, why do we have bases in Europe and Japan? Are they going to be there for another 20 years, 50 years, 100 years, 200 years? I mean, what is the end game on that? And you know, I'm sure that there are answers to those questions, but what bothers me in particular is that we as a nation are not having these discussions. I think it's been very dangerous that we have a foreign policy establishment, and I think you heard the general very ably, you know, express concerns about the challenges to the United States. Well, I think the American people have not been brought along on this journey that explains why do we care whether whether the border between Ukraine and Russia is this river or that river, and whether the Russian-speaking areas of eastern Ukraine belong to Russia or Ukraine. I mean, again, I think there are very good arguments on that. I have heard those arguments, but I think nobody has really made the case to the American people in a sense, what is our mission in the world? I mean, the Soviet Union was one thing. Like, is, countering Russian nationalism the same thing? I don't know. I mean, again, I think there are arguments about this, but communism was a clear global threat to our way of life, and it was a military threat. I mean, maybe it was exaggerated, the whole duck and cover movies that we had. I mean, I grew up in the 60s, and, we still, it was after the duck and cover stuff, but, I think we had a sense that, remember like the day after the movie in 1983 about a bomb, and, that was a very real sense. I mean, Russia was a very real military threat. I don't know nowadays. I am somewhat dubious that Russia is looking to conquer the United States or Western Europe. And again, if so, we should just have that discussion with the American people. I feel like our foreign policy elites have really gotten divorced in the last 30 years from the American people. And I think particularly on the conservative side of the House, what does it mean to have a conservative foreign policy? Again, I would say that traditional conservative foreign policy is more, take care of our own, hearkening back to George Washington's farewell address, be very wary of international entanglements, be wary of international alliances. Again, I'm not saying that we should be isolationists. I think this has kind of become a little bit of a, kind of gotcha, that if the second you start to just express some questions about this and say the things that I'm saying, it's kind of anathema, like, oh my God, you're an isolationist. No, I just think, we should have a discussion. I think Ukraine is a great example, because I think so many people want to know, why are we sending billions and billions to Ukraine? Like, if countering, Russia, again, like if the concern is Russia's going to then sweep into Poland or sweep into Germany or sweep into France, again, I think that's, how likely is that? And again, I think that we have focused so much, and I think the general started by saying, we kind of identify Europe, East Asia, and the Middle East as our key foreign policy areas. Again, I am biased, having just been ambassador to Mexico, but I don't understand how we can talk about national security without putting Mexico and our own southern border, the border of our country, not the border between Iraq and Turkey, not the border between Iran and Syria, the United States and Mexico. I mean, let me tell you, talk about a national security problem, that is a national security problem. We have never seen the kind of dissolution of the border that we are seeing now. It is the affirmative policy of one of our major political parties, of this government. And so, at a time when we're talking about Ukraine and Gaza, it seems to me it's almost kind of surreal that we are not focusing on what actually, in my view, directly impacts the security and prosperity of our country. So, again, I respect the world that the judge grew up in. In a sense, my father was in the Foreign Service during that time. It was very clear. If you were the ambassador to Uruguay, you knew what to do. Like now, I think that people are kind of happy. I could see this when I was ambassador to Mexico. The career people are delighted to kind of have China as the new people. They can devote themselves to countering Chinese expansion and strategic competition. They now have a mission. We have a huge, permanent national security bureaucracy that is looking for more challenges, that thrives on foreign threats. They have us living in code orange all the time. I guess it kind of makes sense. It's the old hammer and nail thing. But the hammer sees everything as a nail, right? I think every threat around the world is suddenly a vital threat to the United States. We'll never, ever live in peace again. And so I just think we need to understand, as the United States, we don't have unlimited resources, right? I mean, if we had unlimited resources, that's great. But I think we live in a world where we have really been on autopilot now for at least 30 years since the end of the Cold War. I mean, I could see this in our mission. Like, they don't know what the heck to do in Mexico. We have it's the largest American diplomatic mission in the world, okay? The diplomats now, kind of shockingly to me, They don't believe promoting foreign commerce is part of our diplomatic efforts, right? In fact, commerce got taken out of the State Department and moved into the Commerce Department. So if you're a Foreign Service officer now, that is not even on the radar screen for you. What are these people being told? They're being told American foreign policy is all about American values, right? So that's why we have people, raising different flags for different groups on American embassies, and this is what American foreign policy has become nowadays. And, I think we need to have a real adult discussion in this country about what are the real threats to the United States? Again, why are we more focused on spending so much more in Ukraine than we are on our own border? I think a lot of people would regard that as a very strange choice. To go back to one point the general made, I think there's just a very massive problem of accountability in this whole foreign policy world. And it was a new world for me, okay? I am the first to admit, I was a lawyer for 30 years. I am a lawyer. I think it's very useful to have people who are not the people who grew up entirely in the foreign policy world and take for granted all those assumptions, come into that world, and particularly people with a view of limited constitutional government, and say, what the heck are we doing spending all this money in all these parts of the world? But we had probably one of the most disastrous things, and I think I agree with the general that one of the reasons we have the invasion of Ukraine and Hamas and Iran, everybody's so aggressive, is there was almost nothing more pathetic than our withdrawal from Afghanistan. I mean, it was just a total national humiliation. Obviously, that engenders all kinds of mischief, but there was no accountability. Nobody was fired for that. Nobody. It's just astonishing to me. But I could see that in the embassy. Nobody gets fired for anything. There's no accountability for money, for results. All people do is set up meetings. So again, I think there's a lot to be discussed. And I think in particular, again, I'm glad to be here at AEI because I think it's very important that we who regard ourselves as conservatives kind of hash out these issues amongst ourselves, because I don't think it is at all clear to conservatives what is a conservative foreign policy. Is it, democracy or a threat to democracy anywhere is a threat everywhere? Are we going to continue that model, or are we going to be much more discerning about identifying what our key national interests are and really revisiting, I think, a lot of the assumptions? So anyway, I look forward to this discussion. Thanks, John.
Thank you. Professor Gruvio.
Thank you, John. Thanks for having me on this panel. As I mentioned to you, ma'am, I did not have the pleasure of knowing the judge, and therefore I speak somewhat as an outsider to this group on foreign policy, although John made it abundantly clear that we're just going to talk about foreign policy. But as an academic, the first thing I did when John asked me to be on a panel was actually to read the articles that Judge Silberman has written on foreign policy. And one in particular struck me as quite relevant to the topic of the conversation, actually some of the points that have been mentioned, and to the moment in time that we live in. And it was an article that he has written in 1979 in Foreign Affairs. So I guess it was just after his post in Yugoslavia as an ambassador in Yugoslavia. And the article starts with a very clear statement of what the argument is. It's a simple and therefore brilliant statement. He says that foreign service officers should not routinely occupy senior policy positions in the State Department. By the way, that should be something reprinted every November of elections, especially if a Republican wins. And the article, it was a simple argument, but it was actually very well argued, and there are several, actually fairly deep, simple points in it. Allow me to quote a few. Why is it that he seemed to be opposed to foreign service officers occupying senior policy-making positions? And he says, for the simple reason that, as he put it, if the Foreign Service sees itself in competition with the political appointees for senior positions, the Foreign Service will instinctively resist presidential direction of the substance of foreign policy. In resisting the legitimacy of political appointments essential to presidential control, it, meaning Foreign Service, will inevitably reject as well the legitimacy of political direction. He's writing this in 1979, and he, perhaps to calm down the Foreign Service officers who'll say, well, the change, don't worry about it. Change between presidents is not going to be that big, he says, because there's a narrow degree of ideological differences between our political parties, both in terms of the domestic and foreign policy. This was 1979, and we might question whether that's the case now. But why is it that, another reason why he seems to have opposed foreign service officers as occupying senior policy-making positions? He had a brilliant paragraph right in the middle of that essay, and allow me to quote it again. He says, "The average American has a sounder instinctive grasp of the basic dynamics of foreign policy than he does of domestic macroeconomics, the management of which, macroeconomics, is after all the most important domestic responsibility of the government. Common sense," he continues, "the sum of personal experiences will take one further in the realm of foreign policy than in macroeconomics. Even children playing together begin to learn lessons about the balance of power to prevent one from dominating others." You don't need Henry Kissinger to know that. But they manifestly do not learn the way people behave economically in the aggregate. So the point being, look, foreign policy is not the realm of esoteric expertise, esoteric knowledge, a narrow expert class, foreign service, or academics like myself. It's something that the average American has a sound instinctive knowledge and therefore, should be listened to. Hence, the president matters. He's the one elected, and therefore his presidential authority, legitimacy, ought to be implemented, including in a place like the State Department. Why is it important, especially for this moment in time? I think and maybe there was mentioned already a little bit before, is that and the wars in Ukraine and in Israel in particular, have raised a lot of questions or tensions, in particular in conservative circles, which I think is good. And these are questions that arise from the average American person. They have certain sensibilities or certain instincts about foreign policy. And these questions, tensions, don't have clear-cut answers yet, and they probably shouldn't, and probably will never do. But I think what they do is they challenge certain views that were predominant over the past 30 years in our foreign policy. And that those views may not be fully attuned to both the geopolitical realities and the domestic requirements. So just for the sake of time and to let other people ask questions, let me just mention 3 of these tensions and questions that I see sort of the average American having certain instinctive sort of interest in these questions. The first one is, what are the prospects of change in our rivals? Russia, Iran, Hamas, China. I think that the predominant belief over the past 30 years was that democratic regime was possible in many places, if not universally, and it was likely to occur at some point in time because both of international pressures and popular domestic support. The ineffectiveness of authoritarian regimes would sooner or later lead to a progressive march towards democracy, and through that, toward a more harmonious world. Rivals will become friends. Russia will become a friend. China will become a responsible stakeholder. And sooner or later, Iran will return to some sort of, Iran and all of its proxies will return to some sort of better relations with us. But I think here's the tension. It is reasonable to ask whether that is the case. It is reasonable to ask whether Russia will actually change in any meaningful way in the short, medium, or long term, for that matter. It is plausible to ask the same in terms of not just Hamas and leadership, but what's the alternative and what is next, there or Iran. Certainly in China, it is reasonable to ask whether whatever change may happen is going to be towards a more harmonious relationship. The problem, in other words, is that there may be some cultural, deeply ingrained realities that will not lead and will not result to in a convergence among us and our rivals. It's a question. I don't have an answer. The second question, again for the sake of time, how much should or can the U.S. help the frontline states? Think about Ukraine, Israel, Taiwan, and a few others. We certainly benefit from the regional orders that are present in those places, but it seems to me it's pretty clear that We cannot be omnipresent because we are not omnipotent. We can't do it all the time and in every place. In other words, the United States cannot hold the perimeter, the entire perimeter in all of these three regions against the more aggressive and more assertive authoritarian powers that behave either directly, like Russia, or through proxies, like Iran and Hamas. So Ukraine and Israel are great models for the future, I think. It's frontline states that are willing to incur enormous cost and sacrifice to defend themselves, attain security, and involves actually, in the case of Ukraine, enormous casualties, big sacrifices. But the question is, what about those states that are not willing to do that, that are allies? Not everyone is rearming as much as they should. Obviously, European countries are often the ones that are brought as an example of that. Germany comes to mind. But Taiwan is also, the next frontline state that is not spending as much as it should and as much as needed given the security conditions of the region. Then what? Do we continue to defend these countries, that is, spend our money to extend credible security guarantees, and if need be, to defend and protect those countries, even if they are not willing to engage in, to incur sacrifices and cost to defend themselves? It's a reasonable question, again, that I think appeals to that average American sensibility. My last point, and I'll end on that, the third question. What are the trade-offs? We are accustomed to think, especially since the 90s, that we had economic and military predominance, and we did not have to deal with multiple fronts on different continents. The European theater was deactivated, was peaceful. The Asian one was seemingly becoming a place of, again, great convergence between responsible stakeholders, China and us. It's different now. We face determined rivals that are spending money and using military force to alter the status quo in their respective regions. They're probing, challenging the locals, but also our reputation. And they're doing it at the same time. As General mentioned, we have two theaters right now. The theaters that we actually thought that were the least likely to erupt, perhaps, they are quite active, and they're attracting a lot of our attention and resources. What do? Are all regions, and here's the question, are all regions equivalent? And if so, if the answer is yes, can we defend order in all of them through our capabilities? I think, again, going back to Judge Silberman's point, the average American has a set of questions on this. And the answer may be yes, but it hasn't been offered to them in any meaningful fashion. And the sense is, for the average American, seems to me that the trade-offs are present. It's not just about domestic and foreign spending, but just between the regions, that some regions may be more important for a variety of reasons than others, and we ought to devote our attention to that region or that series of regions rather than to all of them in an equal fashion. Last point, these are questions, they're not answers. I mean, I have my own, other people have their own. But I think it's interesting that most of these questions arise actually on the conservative side, to bring it back to the conservative foreign policy, which I think makes the sort of conservative foreign policy much more lively and interesting than the liberal one. In general, it's always more interesting, but given there's a debate, I think it's more interesting. And I think it has to do with that appeal of conservative foreign policy to and of the average American voter. It's not driven just by some sort of overarching ideological view of the world. It's driven by, to a certain degree, by the sensibilities of the average American. And well, those questions arise from it, and that's why they're present in the conservative foreign policy. So let me end on this, because I think we're past our time. John.
Thank you, Professor. Chairman Keene, would you like to answer some of these questions that have been raised? You don't have to get to all three of Jakob's questions, but I think Judge Silberman would have loved you. But I think Ambassador Landau, he's asking for an answer. Why are we in Ukraine? What is the explanation that the American people can accept for our commitment there? Or are our commitments are they outrunning our resources and capabilities?
Well, first of all, I think Ukraine has to do with where is Russia. And Vladimir Putin, when he came into power in 2000 and now in power greater than that, has always had a couple of major foreign policy objectives. Many people think it's a return to the Soviet Union. It's not, because he believed that was a failed concept that led to the dissolution of the Soviet Union, economic collapse, overextension, etc. He wants to return to the Russian Empire. And he's had to achieve that. He's always believed the major impediment and obstacle to that is the transatlantic alliance led by the United States and in NATO. And he's established goals, and he fundamentally resents the fact that many of the Eastern European countries that were part of the Soviet Union are now part of NATO. So he's quite publicly and quite consistently has talked about returning those Eastern European states to be part of the Russian Federation. And the fact that he has aspired to that over the course of many years, I think we should have a tendency to take that serious. After Georgia, for sure, and intervention into Syria, to prop up the Assad regime at a time when the United States was not doing maybe as much as they possibly could. And certainly the intervention into Ukraine. He saw the previous administration provide lethal aid to Ukraine, and I think he came to the belief that if he tried to impose his will on Ukraine during the Trump administration, there would be a reaction to it. Having spoke to the president about this myself, he told me that he told Putin exactly that you're going to get a reaction from me and you won't like it in so many words. You know how he talks, so he talks like that. And I think Putin probably understood it. In March of this year, in March of 21, 60 days into the Biden administration, Putin put 70,000 troops on the border of Ukraine. And the president was asked, what are you going to do about that? And his answer was, I'm not going to do anything because I don't want to provoke him, quote unquote. So if you're on the receiving end of that, Mr. Putin, is that an incentive? Possibly. Then he was asked, well, what happens if Putin goes into Ukraine? What would you do about that? He said, depends on how much territory he takes. So Afghanistan occurs in August. And while everybody focuses on the fiasco of what took place in terms of an emergency retreat, I'm absolutely convinced in what our adversaries, as well as many of our allies, learned from what took place there, was the judgment decision that was made to pull away from an ally we had been with for 20 years. All of our NATO allies who were still in that country, collectively they had more troops there than we had, and they all advised the president not to pull out. But we walked away from that ally and surrendered the country to the very adversary that we were opposed to. That, I think, is the lesson that they learned, not so much that we didn't know how to conduct an emergency retreat and it turned into a fiasco. It was the policy question. Policy question. And you can argue whether you should stay in. There's good arguments on both sides of the issue on in Afghanistan, out of Afghanistan. I'm not trying to relitigate that. I'm just trying to enlighten about what is going on in people's minds when they watch this. That was August, the end of the month. In September, the buildup began on the Ukraine border, and it led to 170,000 troops on the border. I'm absolutely convinced in my mind that Putin's ambitions are beyond Ukraine, but his fundamental issue in not only taking Ukraine and taking ownership of it for some false, somewhat historical reasons, he's arguing over it. Putin is very good at false narratives, as you can tell. He'll create one for just about anything he's doing. But the reality is that his ambitions go beyond it. And I think we should take that seriously. And we have an opportunity here. The Ukrainians have caused 300,000 casualties to his combat forces. They've set his combat forces back about half of them. They've literally beat his airborne infantry, his naval infantry, his tank guards army, which is the very division that's protecting them in Moscow when they sent that in there, elements of it. They beat that. They pushed back on some of the maritime power in the Black Sea. And Putin is set back as a result of that. What does that cost us? No American blood has been shed. $44 billion in terms of military investment. And this is so misunderstood. None of that money has gone to Ukraine. What we did is we gave $44 billion worth of military stock that we have in our arsenals. We've given that to Ukraine, and then the money goes to the defense industry to buy not just the product back, but the improved version of it. So that's increasing our arsenals. Who benefits from that? American economy, American worker. We haven't really explained that very well to the American people. Europeans are coming close to almost 44, they're somewhere around 40 billion investment themselves. Misunderstood, the Europeans aren't pulling their weight. 12 European countries, if you looked at their GDP, have a higher percentage of GDP contribution to Ukraine than we do. No, the European countries are mere shadows of their former self during the Cold War. Their militaries are much smaller, with considerably less capability. So many of them are actually punching over their weight, particularly the Eastern Europeans, the UK, and the Nordic states. So my point is this worth the funding? I think it's an unbelievable return on the investment in terms of what we get out of this. No bloodshed, a modest contribution out of an almost $7 trillion budget. Remember what I just said? This is less than 1%. And we have set back Putin, and I think set him back a number of years for sure. And it's not a choice between the border and Ukraine. I mean, give me a break. This administration has made that choice for us. They're not going to fix the border. I mean, come on. Why would you, to make that argument and say, because the policy of the Biden administration is we're going to have an open border and cater to his far left base, and he wants to fund Ukraine, which makes sense in terms of our own national security, we're not going to change Biden if the Congress says no tomorrow. Is that going to change Biden? And he's all of a sudden going to take that money and fund the border? That's absurdity. It's not exclusive of each other. The right administration with the right policy understands that our national security begins at our border. Begins at our border. And of course it should be enforced, our national laws to protect us from people we don't want to have in the country who are going to do us harm, and somewhat vet the people that are coming through. I mean, my God. Yeah, so do I sign up for funding Ukraine? I think it's a modest investment. And the Ukrainians are doing the fighting, and all they've asked us to do is give them the equipment to help them. And even here, the Biden administration, because from the very beginning, they wanted to get to the negotiated settlement as quickly as possible. They have held back, given them the resources to really achieve a victory. And what they're trying to do is prevent a Ukrainian loss. And I would suggest those are two different policy objectives. Even many of the Europeans now have seen it. The last NATO summit at Vilnius, most of the European countries said, we were wrong in the beginning. The right policy is all in, give them everything we can give them so they can get on with liberating their country and stop doing half measures, which is the United States policy. We're aligned with Germany now on slow rolling equipment into Ukraine. So this is an interesting discussion that's taken place. Last week I spoke to 25 Republicans who have issues dealing with on the House side. Next week I'm speaking to over 70. next Tuesday or something, 12:30, and deals with should we fund Ukraine or not. And I'll make an argument similar to what I made here with some other details. But yeah,
I thought the Iraqi surge was a hard problem. This might be harder for you.
well, the Iraqi, I mean, we were losing a war that we were involved in, and we had the wrong strategy. The generals were wrong, Rumsfeld was wrong, and they wouldn't change it. And we had a president who was willing to change the strategy. The surge is a media term, but we changed the strategy. And I was in the Pentagon this week challenging Pentagon leaders, look at the strategy we've assigned to ourselves, look at the assumptions we've made, stress test those assumptions, and see if they still hold up. I don't think they do, to be frank. But 3 years into administration, it's tough to ask an administration to challenge its strategy and challenge its assumptions because they start to get comfortable, about where they are.
Let me ask Ambassador Landau whether you're satisfied with this answer, but also, I think as a general referred to, I think in the last vote on Ukraine funding, half of House Republicans voted against funding. At the same time, you see, I think, overwhelming support amongst Republicans to fund Israel. Right? Chris, how can you distinguish between one versus the other? I think that's a question Professor Grigio is asking you. Have you already prioritized where in the world you're willing to spend resources, and why prioritize Israel but not Ukraine? Or are you willing to treat them the same and say we should not be funding Israel in its response to the Hamas attacks on October 7th?
I think a lot of us who grew up in the Cold War wouldn't believe at the time that within our lifetimes the Soviet Union would collapse. I mean, it all happened so suddenly in 1989. That was a moment of unique weakness for the Soviet Union, for Russia. Not only to have the communist government collapse, but to have the Soviet Union itself collapse into constituent republics and declare independence is something, again, I never thought that I would see that in my lifetime. And frankly, nobody was really writing. Judge Silberman actually was one of the few who kind of opposed, I think, Kissinger and détente back in the 70s, and actually was kind of a hawk and said, we should actually not just accept the communist control of Eastern Europe. And, I think he was actually proven correct in that. That being said, again, I don't know that the United States has traditional enmity with Russia. I mean, we were not enemies of the Russian Empire. We were on the same side in World War I until the Tsar was overthrown. It is not surprising to me that Putin would have irredentist tendencies if you have lost half of your country at a particularly grim moment in your history. I would frankly be shocked if a leader in Russia emerged that didn't want to try to reassemble the old empire. Not as the Soviet Union, but in some form, that was Russia's weakest point. I mean, almost every nation dreams of its glory days. In Mexico, they still talk about us taking half their territory in the Mexican-American War. Every time I posted a map of the United States, I would always get the response like, well, about half of that was ours. So people have long memories in countries. And, I think the question is, again, Ukraine, for most of my lifetime, was not an independent country. It was a constituent republic of the Soviet Union. I don't know that a lot of these borders necessarily are, ancient, historically venerable borders. I mean, again, Ukraine has a heavily Russian part of it. I heard the general saying that, Putin, he wants to reassemble the Soviet Union. I guess the fundamental question is, why is that a challenge to the United States? Like, what is our national interest, whether or not Putin actually does, get either a direct takeover? I mean, again, are we gonna send American troops? Are we gonna, frankly, I think I don't think we ever had a discussion in this country. What was the purpose of NATO after the Cold War? Why were we expanding NATO into the very doorstep of the Soviet Union, of Russia, after the Soviet Union was gone? I think it seems to me that's a legitimate question to ask. That was not a foregone conclusion that that former Soviet republics were going to be incorporated into NATO. I think we would be very concerned if Mexico entered into a military alliance with China or Russia. I can certainly tell you that. So I can't say that from Russia's point of view, I find it shocking that they are very, very concerned about us playing footsie with Ukraine and talking about Ukraine coming in NATO. I mean, Russia, the Rus actually started in Kiev. And Russian civilization is really very intimately connected with Ukraine. It's not like two completely different countries.
Actually, I mean, those former Soviet republics, they wanted to join NATO because they lived under the boot of Russia.
Yeah. Well,
Crying out loud. I mean, it's pretty obvious. Right. Yeah, we called it the Soviet Union, but who's running the Soviet Union?
Look, I'm sure
Russia.
Guyana would love to join a military alliance with us today too, because Venezuela's threatening it. Like
they lived. It affected their economic well-being.
I get it.
It affected the growth of their children. It affected. They knew what was in the West. They saw it all the time, and they wanted the protection and the security because they didn't trust Russia.
Right, but why is it the United States? I get that, but why is it the United States that we're going to send out? We're going to commit in a military alliance. Which again, George Washington in his farewell address says, don't get in these entangling military alliances. Why do we have these long-lasting military alliances against not worldwide communism, but against Russian nationalism? Okay, maybe there's answers. I'm just saying, I think that this is a debate that we did not have in this country about NATO expansion.
The stability of Europe and economic prosperity
First of all,
of Europe that
is
we're tied
massively
to.
Okay, this is starting to sound
like a Supreme Court oral argument.
We don't want that. Walk away from Europe? No, I said, but this is what becomes this
Chris, let me pause you there. I want to get the last 15 minutes for the audience. I already saw a number of people are leaping out of their seats to argue with you, Chris, which is a common reaction to you in town. But and so because of that, I was going to ask Professor Grigio the question he's asking us is, given that we have these three hot spots, which are, as General Keynes mentioned, are challenges to the American order, and we have limited resources. How do we prioritize? How do you prioritize Taiwan versus Israel versus Ukraine? But I want to give people an opportunity to ask. Edwin Williamson, who used to be legal advisor at the State Department, please go ahead. Oh, wait for the mic. Okay, there you go. Please.
This is a lead up to a question. Is this on?
Yes, it is.
General Keane, but he answered my main question. But so Robert Kagan had a 3.5 page opinion piece in the Sunday Washington Post, and it's called "A Trump Dictatorship is Increasingly Inevitable. We Should Stop Pretending." And the gist of the piece is that there's lots of winds backing Trump at this stage, and we've got to do something to stop him, blah, blah, blah. One of the things he talks about is in Trump's advantage is that he is not running as an incumbent. And part of the advantages that he has is, quote, "On Trump's watch, there was no full-scale invasion of Ukraine, no major attack on Israel, no runaway inflation, no disastrous retreat from Afghanistan," which I thought was a pretty good argument for supporting Trump. But and the question I had, which I think you answered, was why those things happened or did not happen in the case of the invasion of Ukraine under the Trump administration. But given where we are, as you mentioned, and given the Biden administration's failure to basically say, stop it and no more, can we expect any better outcome in Ukraine than basically drawing the border where it exists now with Russia in charge and control of a chunk of a portion of eastern Ukraine?
Yeah. Well, first of all, I don't get into the political aspects of things, so I turned Mr. Trump down twice when he offered me Secretary of Defense. And I don't want you to draw any unusual conclusions from that, but I also argued with him about putting a general in as the Secretary of Defense, which I thought is ill-advised. We try to stay independent of the political system, and I tried to suggest to the president-elect that at some point you're going to want your political appointee, who is the Secretary of Defense, to help you with your political objectives, not just your national security objectives, which is quite appropriate. But military generals in that, or an admiral in that position, is going to resist that because we try to stay independent of the process. Not that we don't have generals who are political, we have some, to be sure. But anyway, I think the Ukraine situation, we are way behind what we should have done in terms of giving them the support they should have had. I'm convinced what the Ukrainians have done is their first objective was to prevent Russia from taking over the country, and they have accomplished that. And much to everyone's surprise, to include my own, they punched above their weight, and what Russia put on the battlefield was something completely less than most of us expected. And they still have those systemic problems. But they have more people, and they've got a strong industrial base that's going to be able to continue to support their troops on the battlefield. In my own view, I don't see Ukraine losing any more territory. So that's step one. That's a good thing. Every offensive operation other than Bakhmut that the Russians have attempted, and 3 in the last 2.5 months, they failed at. And I think they will continue to fail at. The issue is, will Ukraine be able to liberate more territory? When the Russians came in, they did take additional territory, plus what they had from 2014. Ukrainians have taken 50% of that back. Whether they have the offensive capability, even when we give them more capability than what they just had, remains to be seen. I think they will likely be able to take more territory back, but not all of it. And that's just the reality of what they're facing. Putin right now is willing to negotiate. And I'm talking to Ukrainian officials. And some of them are in town here as we speak. But then they don't want to negotiate because they want to liberate their people. And you got to understand the emotion that surrounds this. I mean, if you're under the boot of the Russians in one of those occupied territories, life isn't what it should be. Males have been tortured, women are routinely raped, young, old, and grandmas. I mean, that's the horror of it. And there's now tens of thousands of children that have been taken out of those occupied territories, and they take them away from their parents, and they put them in Russia. And that has been going on continuously. So where Zelensky is, if he tried to negotiate today, there would be an uprising in Ukraine over that, because they want their people back. It's the liberation of the people that they're interested in, and the territory. I think if we challenge the assumptions the administration has made, and that's my point with the Pentagon, et cetera, and reverse our course and give them everything they need as soon as possible, they can take more territory back. And I think that would put more pressure on Putin, to be sure. And I think there would likely be some kind of settlement that came out of that. If you ask the Ukrainians today, do they want it all back? Yeah. But politically, they can't say anything but that. So there is opportunity there. Protracted war favors Putin. He wants that protracted war. You understand, he just isn't interested in the territory and Ukraine. He's interested in weakening the United States and weakening the Europeans as well. The incentive as a result of that for President Xi, if Putin wins in Ukraine, I really believe that President Xi sees that as a major victory, contributing to the weakness of the United States even further. The allies that this administration has cobbled together in the Indo-Pacific region, building on the previous administration, is one of the positive things they've done with their strategy. But many of those allies are also providing humanitarian assistance to Ukraine, not military assistance, but humanitarian assistance, because they're vested in that outcome. They recognize if Russia wins there, President Xi is incentivized to get more aggressive himself. And I'm convinced the Iranians feel the same way about it.
Professor Gurgil.
Just if I may add to that, I mean, the question to me is not what is the particular line that the border will take between Ukraine and Russia, but how can Ukraine, and with our help, achieve a situation in which Ukraine is a sovereign, powerful state? And that involves, I think, geographically, a couple of things. One is have absolutely access to the sea lanes, because that's key for their shipment of grains. And that happens usually in the early fall. That's their push towards essentially denying Russia, I mean, sinking a lot of Russian ships, actually, a pretty large number of ships. And they've achieved some of it. But the second was actually regaining control over the Azov Sea, which is the internal sea. Mariupol is on it, which they lost. There's a lot of there was a lot of industrial capability there and agricultural land, which is key to their economy. A third, and that's their own doing mostly, is have a political situation which is free of corruption, which they're not managed to do, unfortunately, that would incentivize the rebuilding of the country, and above all, incentivize the 10 million or so refugees that are, some of them are internally displaced, but they're 4 or 5, depending on how you count, abroad, to come back. That's an enormous amount of workforce that is not there, that will be needed for a country of 40 plus million, and when you have about 10 displaced, that's a substantial amount that does not make economic rebuilding of the country feasible. And so they have to figure out how to do the internal aspects of their political system and corruption and remove that in order to rebuild it.
Jeremy, did you have your hand up? No? Stuart Taylor. Oh, wait for the microphone, please. Okay, there you go. Thanks.
Hi, thank you for teaching me a lot about a lot of things. Can you teach me something about China? My question. And the China threat, if that's a good thing to call it.
Who do you ask the question of?
So you just want general discussion of China? Great food.
When I
don't want to ever step
before
foot
I
on the
came in
territory.
here, when I worry about the future of our country, I worry less about Iran and I worry less about Russia than I worry about China. But there hasn't been much, and maybe that's naive of me, but I haven't learned much about China and that threat today.
So about Ambassador Landau, your skepticism of overseas commitments, would you apply that to China too?
I think China has eaten our lunch from a commercial perspective for many years now, and they've gotten to be a very wealthy country. They have obviously built up a very impressive military. The question is, to what extent are they a military threat to the United States? I mean, I think we should certainly regard them as a strategic competitor and try to close off all the ways in which they have basically taken advantage of the world economic system unfairly. And I guess I'm a little bit worried, as I kind of alluded to earlier, that we are now glomming on to the military-industrial complex is glomming on to the next big thing. We have always, just to go back to what the general said, I have never in my life, I'm 60 years old, never not heard we are living in a time of extremely dangerous threat. This is the most grave threat. I've heard that my entire life, okay? Like, I just think we have a military-industrial complex that is completely vested in everybody believing that, to having all of us live our lives in code orange. I think we have to take the Chinese threat seriously. I think the most important thing about the Ukraine, quite frankly, is what signals does that send to China? I think that's the conversation we need to have, because I think that is, if there is a global threat to the United States, it's going to be China. I don't think Russia is what it was. So I agree with you. I think we need to talk about China. All the discussions, in a sense, none of these other regional conflicts, I think, are a threat to the security and prosperity of the United States. China is. But I am not convinced that we need to go into a place. I'm afraid that we're going to overreact now. I mean, one of the great things Trump did, I think, is for the first time say, wait a second, China is a strategic threat. That was a very important break with the past. But I'm worried now that we're going to go too far in that direction and gear up our whole military-industrial complex towards a conflict with China.
How about you, Professor Grillo? If your question is how do you prioritize threats, is China the obvious leading threat, and how do you come to that view?
Yeah, I think it is the primary threat for a variety of reasons, just size, economic capabilities. We can't outspend and out-innovate, I think, as we did against the Soviet Union, which was relatively, I mean, it wasn't easy, it was a problem, but we could have done it. It's harder to do with China. But having said that, though, I don't think that means that we should ignore, therefore, Israel or Ukraine. In many ways, it's a blessing in disguise that those wars happen now, not 5 years from now, which would have been much harder for us to do when the Chinese really are growing. So I think we have an opportunity to actually to stabilize those regions, like in particular with Russia, and then put our effort towards China. One thing is, I actually, with Ambassador, I remember I have this agreement. I went to grad school never hearing the term threat. And it was, in the 2000s. The whole idea was there are no more threats, they're all challenges. And I hate that term. Even like my kids tell me, I have a challenge. I mean, it's not my problem. It's your problem. So challenges like, global challenges that require global solutions, right? I mean, that was mostly liberal, but a lot of, on the conservative side, we kind of adopted that too. Threat, I think, is something that is coming back as a term, thankfully, because it has some analytical clarity. And so I think that's I don't know if it's new in a sense, but it certainly was not there in the previous 10, 15, 20 years, where the problems, the challenges were either global or sort of leftovers from something, dead enders that didn't get the message yet. This is different. These are not just sort of small challenges, dead enders that need to be solved. These are serious threats that I think are going to be long term. They're going to outlast us, our lifespan, because of just a deeply ingrained rivalry and the effort that those enemies, we call them competitors, rivals, really enemies, are putting into that.
I need to comment on
Please
China,
go ahead.
all right? I mean, we were talking about Ukraine and the war in Gaza as topics, and you introduced this one, and it's the elephant in the room, to be frank. I pay attention as my start points in terms of what is the country trying to achieve. And President Xi is completely different than his predecessors. He's very open about it, and he talks about it every single year, and he wants to dominate and control the Indo-Pacific region, and he wants to replace the United States as the world's global leader. He wants to dominate economically, technologically, militarily, and geopolitically. Those are his statements. And then he puts in play a strategy to accomplish all of that. And it's playing out right before our eyes. In 2015, he established the artificial islands in the South China Sea. Obama said, "What are you doing there?" He said, they have no military application whatsoever. They're completely militarized, as we all know. He has stated time and again that if Taiwan doesn't voluntarily come into mainland China's control, that he will take this by force. And he's been intimidating, coercing all of our allies in the region. We're never going to be able to put together a political and military construct like NATO because the governments there are so different socially, economically, etc. But nonetheless, I give the administration some credit for stitching together some alliances, some bilateral, some trilateral, and then there's the Quad, which is Australia, United States, Japan, and India, and stitching together some cohesiveness to be able to stand up against it. The backdrop for all of this is the erosion of our military capability. And I have been spending time on this for the last few years. I can't get into the details of all the classified stuff that I've been briefed on, but the fact is we are behind. And since the last time our commission looked at it in 2018, the National Defense Strategy of Trump and Mattis, and now we're looking at Biden and, Austin, we've gotten further behind. It's not just they have more airplanes, more offensive missiles, more ships than we have. It's the fact that the qualitative improvement they're making is quite dramatic. And the industrial base is so robust. If you put a plan out, where are we going and where are they going, it's hard for us to catch up. That's the reality of what we're dealing with. And what are we trying to do here? We want to do what we accomplished during the Cold War with the Soviet Union. Put in front of them deterrence. And what is deterrence? It's two things. It's one is the capability your adversary sees will impose cost on them if they take an offensive move against you militarily. And the second thing is, do you have the will to use it? I think there's a question mark dealing with the will with this administration. Not only that, they are not resourcing the military to the degree they need to resource it to give us the capability. It's a matter of public issue that when we play war games against China, we lose. And I think Chinese, probably the leaders like me over there, play the same war games we're playing. This is serious, what we're talking about. Now, I don't get all wrapped up around who wins or loses the war game. I thought war games always serve a purpose that's far beyond that. It's a wonderful way to determine what your vulnerabilities are and where your strengths are in terms of capabilities, and you can change your capabilities in a war game to figure out what you need to buy, as a result of it. So it's an educational and instructive tool that we can use in doing it. But just accept the basic premise that our deterrence has eroded with China. And it's bigger than just dealing militarily with China. I mean, economic, certainly, we are better than they are, and we're going to continue to be better. Why? Because capitalism, innovation, just the creativity of America, we're going to beat these guys economically time and time again, as far as I'm concerned. And what is he doing now? He's pushing back on the private sector and capitalism because of his authoritarian control. He's preoccupied with control. His weakness, his Achilles heel, is the repression of his own society. That is his Achilles heel. But the reality is, we have got to return to strategic deterrence, not just in Europe and in the Middle East I'm talking about. I'm not talking about huge expenditures in those areas. The priority has got to be dealing with China, as you suggest. And we've got to get this thing right. We don't want to provide him with any incentive. And certainly Russia winning in Europe, I think, is an incentive to him. To me, it seems common sense. We just forced the United States and the Euros to take a knee. That's going to impact the allies and their confidence in the United States that was trying to stitch together in the Indo-Pacific region to stand up against China. And that would force them in some degree maybe to start making deals with China that they don't want to make, because the United States is no longer the global power that it used to be. So yeah, China is our priority and should be.
I hate to do this, but we have to end. I'm sorry, sir. We're at 4:22, so we're a little bit over time. So we're about to move to a reception before we hear from Justice Barrett, and we're treated to an interview of her by Paul Gigot, the Wall Street Journal editorial page. please join me in thanking these three leaders in our foreign policy.